I appear for the appellant LBT in this rolled up application for permission to appeal. My learned friend Mr. Patel, King's Counsel, goes to the respondent trust, and my learned friend Ms. Watson, King's Counsel, represents the official solicitor who is here at the invitation of the court as advocate to the court.
And just before you go any further, you've referred to LBT. I've seen one skeleton refers to LBT, another refers to LT. Is there a consensus as to how the individual concerned should be referred to?
I adopted LBT because that was what the transparency order specified.
That's your client.
That's
your client.
I'm happy to refer to her as LT if it's simpler for us.
I see, yes.
And the patient is to be called
RB. I'll be referring to the trust as the trust, and I do need to make reference to various clinicians. I'm just going to use a letter cipher for them, but I'll take the court to their reports, and it will be obvious to them.
Does that apply to the authors of the second opinions?
On one reading of the transparency order, it does, and I wasn't present at the proceedings below. In my submission, the injunctions which were made are not in compliance with the principles which the Supreme Court laid out in the decision of Abbasi Newcastle upon Tyne Hospital's NHS Foundation Trust. But since, in particular, the trust, we say, is improperly anonymised, since the relevant jurisdiction for anonymising public bodies was not made out, wasn't invoked, and also the injunctions against naming the parties or my client, especially since these names had already been published in the national press prior to the hearing. This does raise issues under Section 12 of the Human Rights Act and under Article 8, my client's Article 8 rights to identify themselves if they wish. However, since the injunction expires at 1 minute to midnight tonight, and since the very serious issues which we need to decide, I wasn't proposing to make any application now regarding the injunction. I was quite happy for this hearing to proceed on an anonymised basis. However, if the court were minded to extend the injunctions, then I do have submissions to make as to how they should.
How would you feel if we extended the injunction to such point as when the judgment is handed down and reserve the question of anonymisation of the judgment until that point?
Well, the court's obliged.
Obviously, I ask that because we really want to focus on the substantive issues, not diminishing the other issues, but it's a question of priority, Mr. Quintivani.
Well, my lord, the court's obliged to act compatibly with the convention, and to do that, we say would be incompatible. We say the trust at the hospital should be identified, and so should my client. We are happy for treating clinicians, but not second opinion doctors to be anonymised. If the injunction were to protect treating clinicians and nursing staff in the interim, then I have no objection to that. But as I say, perhaps that's a matter we can deal with after.
We obviously don't want to spend a lot of time on this because we actually want to deal with the substance of this matter. Mainly, though, this is going to be a live issue come tonight. What could you put in writing over lunch?
Perhaps I can discuss with counsel. We probably weren't too far apart from the discussions that we had before. It's just, again, I didn't want to get tied down in this.
Well, in that case, can we see what you can achieve over lunch? But it's obviously not going to be satisfactory simply to have the order to expire tonight. Something will have to be done.
Mr. Quintivani, would you allow me just to check the position on one point, Mr. Patel and Ms. Watson, Mr. Patel particularly? So if we were to allow grant permission and allow the appeal, what course would you invite us to take? Otherwise, if we were to say that the judge's distinction between clinical and best interest was mistaken as a matter of law, what course would you invite us to take at that point? What order should we make?
My lord, I think you'd have to quash her decision
Yes.
because it's premised on that. I think if you were to say that this is all a matter of best interest, not clinical decision making, and is a matter of law,
Yeah.
then you'd have to remit it to the Court of Protection.
We were wondering whether there's any, and this is of course subject to the argument we haven't
Yes.
our minds, but if there was, is there any way we could short circuit that process, bearing in mind the urgency of the situation? Is it a decision which we could take, or would it have to then go through a process before it's just time for somebody else?
My lord, I think as a matter of form, this court could take that decision, that best interest decision, if you felt able to do so. But I would anticipate that my learned friend would say that you hadn't got the evidence to do it.
Yes.
But I think you can, as a matter of form, do it.
Yeah. Thank you.
Lord, could I help on the transparency order, if I may? Certainly for our part, the trust isn't anonymised. In fact, the transparency order doesn't anonymise the trust. The identity of the trust can be revealed fully. Given the name of the trust, it's probably very little. There's probably little to be gained by trying to anonymise the name of the hospital, because it's the hospital of the trust. So long as the clinicians, the treating clinicians and care staff are anonymised, we would be content for any order that changes.
The order must be Abasi compliant.
Yes. But certainly, whilst they're treating, whilst he remains alive, it is Abasi compliant, and
Yes.
certainly our submission would be that you keep the transparency order in those terms in effect until further order is death, effectively, and then there's a cooling off period that can then be reviewed in
The order
terms.
suggested you discuss it with Mr. Quintavani over lunch.
I'll certainly do that.
Was that something you wanted to comment on?
My lord, I simply align myself with Mr. Patel on behalf of the official solicitor, so can take that briefly. We would
On the
submit that
What next point?
in respect of what next, yes, this court, as a matter of form, could take the decision, but it is unlikely that that will be something that will be agreed to in the absence of further evidence. In relation to the transparency order, I'm sure we can deal with that over lunch.
Mr. Quintavani, for completeness, where would you say that we would go in that scenario? So if we had decided that the decision under appeal couldn't stand, but it had to go back to the Court of Protection, or would you say we wouldn't need to go back to the Court of Protection? What would your position be?
It's certainly within the power of the court to make the order sought. In terms of the evidence that was before the court below, it's the same evidence which is before the Court of Appeal. There's no live evidence, there's no cross-examination. You're in an identical position to determine the matter. If it's felt that you're not in a position to determine that, what's necessary is that there is an interim declaration, because otherwise any further parts of this proceedings are likely to be totally academic, unfortunately.
Now, there are two sorts of interim declaration. There's an interim declaration which says it is lawful for the hospital to do something. There's another kind of interim declaration which says it's unlawful for the hospital not to do something. Which on your case would it be?
Well, we were asking for both declarations. It's an important point as to what power the Court of Protection declarations have, and the authority is quite clear that they don't have any coercive power. And this is an important point in relation to the appeal, because we're being told that we're forcing doctors to act. In fact, there's no coercive powers. But the court does have powers and again, the authorities are clear on this. And my Lord Justice Baker heard a case recently called Rigi, which is in the bundle, in which the possibility of the Court of Protection making injunctions to ensure that declarations were abided with is a possibility. We're not asking for those injunctions, we're asking for the declarations. We believe that the declarations are made will be sufficient to ensure that doctors will reconsider.
Isn't the declaration, the second declaration that the Lord postulated, tantamount to an injunction? If you say it's unlawful for them not to, isn't that an injunction? Isn't that, to all intents and purposes, a mandatory injunction?
Well, a breach of such a declaration doesn't have any immediate consequence. Of course, it would allow the concerned party to make further application if in the face of any intransigence as a result of that declaration. But the Court of Protection proceeds on a light touch basis, and we would be content for the declarations to be made.
But just to be clear, so supposing one got to the point where we said, well, the decision under appeal can't stand, we can't make a long-term decision, it has to go back to the Court of Protection, you would then say we should still make declarations on an interim basis.
Yes, to ensure that the life-sustaining treatment continues to be provided until a definitive ruling on best interest is made. And applying standard, these are declarations. As I said, we're not seeking any injunctions at this point, but the same principles apply. We say, is there a serious issue, and where does the balance of convenience lie? These are standard principles which you'll be well accustomed to apply. And we say that if those tests are approached, that the answer is very clear where the balance of convenience lies in this case.
It does, I mean, coming to this as a non-specialist in this area, as you'll appreciate, it doesn't quite sound right that you make what sounds like a final declaration, which you say is equivalent to an interim injunction.
Well, it isn't a final declaration because it only lasts until a final declaration is made, and in the same way as an interim injunction restraining publication of a particular publication isn't final. That's until the final declaration or injunction is made.
But you would be asking us to declare that it was unlawful for the trust not to fail to do something for a period. Well, how, on this scenario, could we declare that it was unlawful for them to fail to do something without making a final decision as to what was lawful?
Until very recently, the treatment was being provided. There's no suggestion that it's impossible to provide it. And I'll be looking at, in the course of my submissions, at the BMA guidance, which does deal with the situations where clinicians can rightly refuse to provide treatment. We say it's very clear that this doesn't fall into those categories. If it did, then I accept that the court couldn't order the clinicians to do something that would be contrary to those principles which are set out in the guidance, which I'll come to. If the court's uneasy with what I said, then we're certainly, we say that a declaration that it is, and for reasons which I'll develop, but a declaration which says that it is in RB's best interests to receive the treatment would probably be sufficient, and we don't need to have the second part of the declaration. It will become clear as I make my submissions, I hope, why I say that.
Well, without prolonging unnecessarily these preliminary discussions, given what we've been told about RB's state of health, it seems sadly very unlikely that he's going to survive or protracted litigation back in protection. Can I pin you down on whether you think that it's appropriate for this court to make to deal with a substantive application rather than remitting. The application being whether to grant the client permission to bring the proceedings, which is Section 50 application, which is in issue.
So the question is, at which stage should this court become the substantive application?
Would it be appropriate, rather than allow the appeal and remit, to allow the appeal and make the decision ourselves
Yes.
on Section 50?
Would be, perhaps that would be a way out of the difficulty.
Do you accept that in the context of this case we have the information necessary to make that decision? The context of this case being there's no time for protracted litigation.
I do, my lord. We would. I've indicated that there are certain circumstances which we say don't pertain, but they may in the future, which will make it impossible to provide treatment to RB. And in those cases, obviously, the court can't oblige doctors to do the impossible. And we'll maybe have to phrase any declaration carefully to ensure that those exceptions which are recognised by the BNA are incorporated into the rule of procedure.
Just so I'm absolutely clear, you may want to think about this, but at the moment your position is that if we were to allow the appeal, it would be open to this court to ourselves make the decision on your Section 50 application.
Yes, it would be. And
you accept the proposition that given your RB's straitened circumstances, very severe circumstances, that may be the best course.
it may be, and my lord, of course, in these sort of proceedings, even when the Court of Appeal has, or indeed even when the Supreme Court pronounces, as in the case of Charlie Dove, it's always possible for one of the parties to reopen proceedings before the lower courts if the situation on the ground changes, to ensure that whilst an order had been made before to provide treatment, now that it can no longer be provided, things have changed and a new approach needs to be taken. So an order of this court will be final as far as these proceedings are concerned if it resolves it, but it doesn't stop the proceedings being reopened at a later stage if the situation changes. And that's normal in this sort of, and inevitable in this sort of, in these sort of cases. But we say yes, at the moment.
It's necessarily inevitable, but it's certainly not uncommon.
It's not uncommon.
May I just perhaps reiterate what has been said so that I'm sure for my purposes that if these things came about and you are satisfied that we have the material on which we could make the ultimate decision today in relation to this interest, if that were the test and we were in that place.
My lady, I am subject to the trust not having any new evidence which they say changes the factual situation. We say that and this is on my instructions as the RB's condition, nothing has changed that would render the provision of dialysis now impossible, or would have high risk of mortality, or would not serve any purpose, which are the three conditions to anticipate the argument. But wouldn't extend life. It would extend life. It doesn't have a high degree of mortality such as to render it ethically problematic, and it is physically possible to provide the treatment. That hasn't changed with something.
Thank you, Mr. Pontevine.
My lords, my lady, I wanted to deal with another preliminary issue, but an important one, and it's the issue of the status of RP in this litigation. And my Lord Justice Baker raised this with us at the hearing on Friday. My understanding, and I've spoken to counsel who also, if necessary, has some submissions to make on this point, is as follows. Unlike in civil litigation, under the Court of Protection rules, the appointment of a litigation friend for P requires an order of the court, and that's Rule 17.31a. I can take you to the bargain bundle if necessary.
17.3a.
17.31a, sorry. Such an order was not made in the proceedings below. It's at tab 8, page 18 of the authority bundle. Such an order was not made despite LT naming RB as a respondent to the application, and also a separate application being made once it became clear the official solicitor wasn't willing to assume the role, a separate application being made for LT to be the litigation friend to RB. And no appointment was made, and as we've seen, the application to bring these proceedings under the Mental Capacity Act was dismissed. It didn't meet the permission threshold. But the result of this is that RB was not in fact the party to the proceedings at all, and hence he has no means now directly to take part in this appeal, unless the court makes him a party to this appeal, which I do invite the court to do. But regardless of whether the court makes him a party to this appeal or not, this raises very serious issues, we say, and then once I've modified paragraph 14 of ground 2 to encompass this understanding, which is different from what it was on Friday. And the point, and I'll get to it with reference to a recent Court of Appeal case called We Are the Child. We say that where a matter, where the court is determining something is momentous, as whether someone is going to live or die, then there's a procedural requirement to make that person a party to proceedings.
Wasn't RB a party?
No.
Was not even a party.
He was a respondent on the application.
Yes. So he wasn't represented. Is that the position?
Unless someone has a litigation friend, my reading of the Court of Protection rules is they can't protect the party, can't be a party to proceedings without a litigation friend. And since the litigation friend wasn't appointed, then he ended up not being a party to these proceedings. And I understand my learned friend Ms. Watson says in fact there weren't even any proceedings because permission wasn't given. And we say that adds to the gravity of the situation in terms of access to justice, and these are the points made up of ground 1 as well. But it is a significant point.
But again, as a non-specialist, can it be quite right you're not even a party before you get a litigation friend? I mean, suppose proceedings are brought, naming someone as a respondent. Certainly in the context of ordinary civil litigation, it may be you can't do anything in the proceedings till you get a litigation friend, but that doesn't mean they're not a party.
My understanding is what usually happens in these proceedings is that the respondent, for example, a similar situation happens under the inherent jurisdiction in the High Court, where in proceedings involving children, the child isn't a party to begin with, is listed as a respondent and will then have a CAFCAS officer appointed as a litigation friend. In these proceedings, the appointment of the litigation friend is made concurrently with the order to make him joining person as a party to proceedings. And my understanding of the rules is that it's required to have a litigation friend in order to be able to take part in this.
Could you just show us the rules of that? All the rules in the bundle. I've got the blue.
1.2, which is
Sorry, 17.2.
1.2. I'd take the court to fact.
Rule 1.2.
Yes.
I'm sorry, where will we find that? That's 7.
It's page 15 of the authority bundle.
So we see at 1.22a, the directions that the court can make is that P should be joined as a party. So that's an order that needs to be made in order for P to be joined as a party. The order has to be made.
That didn't happen here, you say?
It didn't happen.
Is that accepted?
Yes.
So we say that's a very serious issue of procedural unfairness, which raises issues which I'll come to in ground two briefly in relation to, and I'll be citing a case which I handed up. It isn't part of the bundle. This is a case called We Are. It's a short judgment.
Was the judgment about Gravesend death?
Yes. So that case, perhaps I can deal with this ground now. It's a short ground, and maybe it's a sensible moment to deal with it. The issue in that case, there were two grounds of appeal that the commission was given for. One was whether the judge should have ordered an adjournment. Parents weren't represented. The second issue was whether the child should have been made, it was required to make the child a party, since the court was determining a very important issue with respect to the child, and that's namely whether the child was dead or alive. But the court said, and that's a tricky area of law, which has not definitively been determined by the courts, the precise status of someone who's been declared brainstem dead. But what the courts do have is a procedure whereby the courts essentially confirm the diagnosis that the medical staff have made in these cases, and usually the court doesn't seem to require much evidence. Sometimes disputes can happen. I was before my Lord Justice Baker in a similar case of procedural unfairness, which involved a child being diagnosed with brainstem death and then later started breathing, so obviously wasn't dead. And that's the case referred to in We Are. And the passages of my Lord are ones which I would also take the court to in a moment. But the issue in that, the court held that it wasn't necessary to join the child to proceedings where the child had been diagnosed as being brainstem dead, because those proceedings weren't determining any issues relating to best interest. It was simply determining factual matters, whether the child was dead or not. And in those circumstances, but we say in the circumstances where the child was being represented by their parents who had a full legal team at that stage, then there wasn't a need there was no purpose served in making the child a separate party to the proceedings. The court had the discretion not to, and therefore there wasn't an obligation. We say that on that basis that the judgment of the Court of Appeal in We Are can be distinguished from this case, because here we say there are best interests at stake, and where there are best interests at stake, particularly where the court is determining whether someone's going to receive life-sustaining treatment or not, then it's necessary as a matter of procedural fairness, but as we will also see when I turn to ground one, it's also necessary under the access to the court obligation, which Article 2 has. It's a positive obligation on the state to ensure access to the court. And we say, and there is also an Article 6 obligation, which hasn't been, which we say could also be made. But nonetheless, under common law procedural fairness grounds, and then when we look at it under Article 2 grounds, it's necessary to make a party in these circumstances, to make a patient in these circumstances a party to proceedings. And that wasn't done. And that's a very serious procedural irregularity.
But to take you back to the rules, page 15 in the authorities bundle, you took us to rule 1.2 A, should be joined with the party, but the remainder of 2 and 3 and 4 make clear that it's actually, as my lord said, in general terms rather than in these specific terms, joining someone as a party who does not have capacity won't actually take effect until there's been an appointment of a litigation friend or an accredited legal representative, and that's at little 4. So those two things go hand in hand. So you need that also in order to move forward. Just
that's correct. I should have taken the call to it. I'm very grateful, my lady, for.
So you need both.
You need both, and there are differences. And the other difference is the fact that the order is needed, as we saw in 17.3, whereas in civil litigation, it's the filing and serving of the certificate of suitability, which, unless the court displaces it, automatically makes someone a litigation friend and therefore entitles them to be a party to proceedings. Whereas in
Doesn't apply here
it
because
doesn't apply.
doesn't apply where the party is P.
Yeah, it doesn't apply, and that was
Reminded last week.
that's what that's what I learned last week as well. I thought, and it was the cause of my confusion.
We were both wrong, Mr. Quintavardi. But isn't it the case that how did the judge proceed on this? No. Did the judge proceed on the basis that it was a case within 122E?
I
In
don't know.
effect?
I wasn't there, my lord, and I'm not sure. It seems I gladly allow my learned friends to enlighten us on what happened. My understanding was that since permission to bring the proceedings was refused, the judge didn't need to deal with any other considerations.
My lords, my lady, my response to that is not quite. The judge below did in effect comply with 1.22E because she invited the official solicitor to act as advocate to the court, which is a course of action which my lord was anticipated in paragraph 40 of Re R as an alternative to making a child or a protected party a party to the proceedings and appointing a litigation friend. So in effect, that is what the judge below did, albeit it was not explicit either in the interactions in the court below or in her judgment or order.
My lord, the problem with that is that first of all, being an advocate to the court is not the same thing as representing the party. It doesn't carry the same obligations, and it doesn't carry an automatic participation in any appeal. But it's also problematic factually because the position the official solicitor took in the court below was to deny that proceedings should proceed at all. And the official solicitor, as advocate to the court, backed the trust position that permission should be refused, and therefore denied P access to the courts. And that's a very concerning position for the official solicitor to take, we say, in the circumstances. So we say the official solicitor was not representing P's interests, and it can't be deemed to have been representing P's interests in the court below for that reason. I wanted my lord and my lady to turn now to ground one after having looked at ground two. Unless the court wanted to.
Are you coming back to ground two?
I wasn't planning to.
So what? If we just took ground two in isolation, what do you say flows from it?
If ground two was taken in isolation, we succeeded purely on ground two, then the matter would have to be, firstly, would be remitted, secondly, permission would be given for proceedings to go ahead.
Just talk me through that.
So, in terms of the why, or in terms of the...
Well, the why, I suppose.
So the why is that there's an obligation, and we say it's a matter, so I can take the court to the case of
But don't perhaps now, but just in general terms, talk me through why, supposing that things had gone wrong in relation to the role of the patient, what would flow from that?
Well, the issue, the fundamental issue of procedural justice is that someone, and this under the common law, someone for whom the court is determining issue which is of relevance to them, and more so when it's a momentous issue like this one, whether they're going to live or die effectively, needs to be a party to those proceedings. They can't be made without the person being a party. And the failure to make RB a party to the proceedings meant that fundamental issue of procedural breached, and the court will remedy that by ordering that, by remitting the hearing so that it can take place properly with RB represented, whoever it may be who represents RB, whether it's LT or someone else, but nonetheless that he has representation and that the hearing goes ahead.
Now, so permission should be given. You mean permission to appeal, or
Yes.
which permission?
So permission to bring the case under, well, if he's made a party, then there doesn't need to be permission, because under the Mental Capacity Act,
Why do you say that?
well,
No permission is required if an application is made by the person who lacks capacity.
so
There's a step you're missing here, isn't there? You're assuming that within the application, the litigation friend would then make the application or support the application.
yes, there is another step, I believe.
But that's the point, isn't it?
Yes,
That
so
they would
otherwise-
join- that would remove the need for any permission under section 50.
Otherwise, yes, permission would be needed under section 50, under rule 50. So we say that it should be remitted and permission given if necessary to ensure that the case is able to be determined by
What permission would then be given? Sorry. So
if you look
if at the stage at which you say, well, something's gone wrong procedurally, I suppose the court, a decision is whether or not P needs to be a party or whether E applies. Assuming that E doesn't apply, then you have to appoint a litigation friend. Are you in effect assuming that would necessarily be your client?
we suggest in the circumstances would be appropriate that it is. We are concerned by the position the official solicitor has taken, and we believe that in those circumstances it wouldn't be appropriate for the official solicitor to continue to adopt the official role. But I'm happy to take instructions that we discussed with.
I mean, a question is, would all this on this scenario be up to us, or would it be back to the first instance judge to decide what to do?
Well, it's certainly open to this court to make those orders.
So just going back to what we said earlier, what impact does that have on what we could then do on the substantive issue?
You would be able to determine the substantive issue in any case, but it doesn't require RB to be made a party to these proceedings. We've invited the court to do so as a matter of propriety, but it's not necessary. The orders are being sought by LT, and they're the same orders that are sought by RB.
There seems to be some tension in that position. If this is a fundamental procedural flaw, how can we decide the substantive issue?
You say we remedy it and move on.
That's why I made an invitation to make RB part of the succeed. And that's certainly for you.
So go back to ground one.
I could look at ground one. So ground one is in two parts. The first is looking at convention obligation on the state and on the emanations of the state, such as the trust. The second is looking at how the common laws dealt with that. And in fact, what we say is when we look at how the UK's chosen to fulfil its Article 4 obligations goes further than required in Strasbourg. So it is important that we look at what the UK says as well. But the first ground of appeal holds that the state's positive obligations under Article 2 require that where there are disputes about the provision of life-sustaining medical treatment, that the affected party has the possibility to bring the matter before the court for effective resolution. And the three authorities I rely on are Glass in the United Kingdom, Lambert and France, and Guard and the United Kingdom. I'll take them in that chronological order. Glass is a case in which a trust became embroiled. It's at tab 38, starting at page 1429 of the authority bundle. It's a case where a trust became embroiled in an acrimonious dispute with the family of David Glass, a young boy. The trust wished to administer.
Just give us what tab is it?
38. So towards the end of the bundle, we've got the three Strasbourg authorities.
Sorry, carry on.
The trust wished to administer sedation in the form of diamorphine to the child, but the mother was concerned that the doctors were trying to terminally sedate her son, so she refused to give consent to this. The trust went ahead without the consent, and a riot ensued in the hospital, and the family were fighting with doctors and pulling the pump out. And anyway, in the background to that, the matter then went to the court, and emergency proceedings were brought by the family by means of judicial review. And in fact, and this is relevant to the submissions that my learned friend is going to make on judicial review, that the application was turned down by Mr. Justice Scott Baker on the basis, and we can see this in the Strasbourg judgment that recounts the procedural background. The application was turned down on the basis that judicial review was too blunt an instrument to deal with a matter like this, and that best interest proceedings should have been brought at short notice. Permission was refused, but Lord Wolfe distanced himself from Mr. Justice Scott Baker, as he then was, on what he had to say about judicial review. And Lord Wolfe said, look, in these sort of cases, where there's an urgent matter to be heard, the court isn't going to raise technical objections about which proceeding should have been brought. It just has to deal with the matter. And you say that's very relevant to this situation as well. This talk about, well, we should proceed by judicial review, apart from the other reasons, misses that important point. The mother took the case to Strasbourg, and the court did find a violation of the mother and child's Article 8 rights, and held that in cases involving medical disputes, it was necessary to be able to bring them to the court, and that's at paragraph 81. And that's the foundation for the other cases, including Lambert and Guard. It's the foundation of the principle that where there are medical disputes, it's necessary to be able to bring these cases to court. Now, it wasn't accepted by the courts that, in fact, the child's life was at risk by this sedation. So it wasn't an Article 2 case. But Lambert and France is an Article 2 case, and this is where we're firmly in the territory of present proceedings too. And Lambert is the next authority, it's tab 39, page 1275. It starts at. And the case involved a decision to discontinue the provision of clinically assisted nutrition and hydration from a man in persistent vegetative state. And this was a dispute between the family where the man's wife said that this is what he would have wanted, and the mother and father said, before the proceedings, and said, no, we don't want our son to die. But the Grand Chamber laid out 3 conditions with which a state needs to comply in order to discharge its positive obligations under Article 2. and it relied on glass, on the access to the court, but it developed it. We can see this in paragraph 143. I should say first, paragraph 124 on page 1308 is saying, look, in cases involving the withdrawal or withholding of life-sustaining treatment, and they don't involve the state's negative obligations. It's not about the state being prohibited from killing someone. It involves the state's positive obligations, so the obligations to protect life and ensure that that Article 2 is otherwise complied with. And at 143 on page 1313, the conditions are laid out. And the first condition is the existence in domestic law and practice of a regulatory framework, they cite glass.
Sorry, I wasn't keeping up. Which paragraph are you on?
It's 143 on page 1313.
Thank you.
So we've got three conditions which a state needs to comply with in order to ensure that it satisfies its positive obligations under Article 2. And so the first is the existence of, in law and practice, of a regulatory framework compatible with the requirements of Article 2, that's A. Then B, whether account has been taken of the applicant's previously expressed wishes, and they refer to the case of Strasbourg application, which isn't relevant to these proceedings. But C is the one that is relevant, and that's this: it's the possibility to approach the courts in the event of doubts as to the best decision to take in the patient's interests. And then that paragraph continues, and it's important that we then see what, because the dispute is whether the decision that was made was about patient's interests. And the court says this, the Grand Chamber says this: the court will take these factors into consideration in examining the present case. It will also take account of the criteria laid down in the Council of Europe's guide on the decision-making process regarding medical treatment in end-of-life situations. And it refers to paragraph 60 to 68 above. We've got the Council of Europe's guide on decision-making in end-of-life situations in the authorities bundle at tab 11, starting at page 377.
Do you want to look at that?
I'd like to turn to page 400, which is the key passage. And starting third line down from the top is the third sentence there. Where patients are not or no longer able to express their wishes, doctors are the people who ultimately, at the end of the collective decision-making process, having involved all the healthcare professionals concerned, will take the clinical decision guided by the best interests of the patient. And this is a point that we see is repeated in the contrary to the submissions made by the official solicitor and by my learned friend for the trust. And this is a point that's repeated in the capacity code, mental capacity code of practice, and the GMC guidance, and also the BMA guidance. And the point is this, that the clinical decision itself has to be guided by best interests. The trust says that clinical decisions are exempt from best interests, that clinicians decide what treatment they offer on purely clinical grounds, and they don't have to consider best interest. And we say this is incorrect. And we'll see why the authorities they rely on a particular bug don't say that. In fact, when a doctor decides which treatments to offer a patient, that doctor has already had to take into account matters such as the applicant's previously expressed wishes in order to decide whether it's clinically appropriate to offer that applicant treatment, the patient treatment. I'll give it, maybe at this point, just give an example. Someone at the end of their life may be in pain, and the doctor may say, look, I can give you sedatives or opiates to take away this pain, but it's going to take away your awareness of what's around you. But the patient says, I absolutely don't want to have my awareness or consciousness reduced in the last moments of my life, and I'm refusing opiates, or vice versa. If the patient says, I can't bear pain, I don't care whether I'm aware of people around me, I want the painkiller, then when the doctor is making the clinical decision as to which treatments to offer the patient, they take that into account, and they're going to say, well, I won't, of the treatments which are on offer, I'm not offering opiates because they're going to take away consciousness, or otherwise this is what I'm going to offer. And that's already that clinical decision is already informed by best interest, and it has to be. And this is confirmed by the Council of Europe's guide on decision making in these circumstances.
Mr. Quintale, that's a very example of something quite black and white, taking into account, as you say, a doctor should, the specific wishes that have been expressed. But would you say that best interests is woven into clinical decisions, let's put it that way, in other circumstances where, for example, the patient isn't in a position to voice their wishes one way or another? In those circumstances, take the wishes out of the equation. What part do you say, I'm sure you'll come to this later, perhaps I'm jumping the gun, best interests are woven into clinical decisions?
Well, the answer to that is that it is incumbent upon the doctor to try and establish what a patient's wishes would be, even where there isn't any immediate evidence as to what they are. In one of the cases,
But is there a different category which isn't to do with wishes or ascertaining what wishes might be, but is truly best interests in the sense of making what would then have to be the doctor's decision about whether X is better for this patient than Y in the circumstances in which that patient is existing at that moment? And would that be clinical, or would that be best interests? Where is the line?
if we look at, and this is at tab 2, we've got section 1 of the Mental Capacity Act, and this says at 1.5 that an act done or decision made under this act for or on behalf of a person who lacks capacity must be done or made in his best interest. So the answer to that is that any, and this is part of our argument, is that any act which is done by a medical professional has with regards to someone who lacks capacity, has to be made in the best interest, and that includes making clinical decisions as they're termed by the trust and by the official system. So we say yes.
Decisions by health professionals are expressly included as decisions
Yes,
in the code of practice,
yes,
and on multiple occasions since.
yes. So we say you can't carve out a category of decisions which are outside the Act or the Code of Practice. All decisions have to take into account best interest. When we look at the BMA guidance, we're going to see that those 3 categories of cases where the doctors are entitled to withhold, there is no obligation to provide health treatment. In fact, as we'll see, are in fact compatible with the Act and are compatible. Yes, they're compatible. We say, I mean, this is a common position. That there isn't any incompatibility between the Code of Practice and the guidance, except we interpret the Code of Practice and guidance differently.
Okay, can I just test the limits for a moment? I mean, suppose that family of someone in this situation wish to have administered a drug that the NHS simply doesn't make available, then you don't get into all this, or you do?
There you get into judicial review territory, because this is about funding and about policy decisions which trusts are making. We accept that as in best interest territory.
And then just coming a stage closer to take another, well, a completely unreal situation. Suppose the family were absolutely convinced that administering a poison would have beneficial consequences. And the doctors say, no, there's no question of administering this poison doing any good at all on any basis. The family think that strychnine is actually contrary to what is understood by doctors, medically beneficial.
Bleach for COVID.
Bleach for COVID, yes, quite. What happens then?
Well, the medical professionals are not, they're obliged to listen to the family, they have to, and to the patient in particular, and to try and ascertain the wishes, but they're not obliged to act upon that. And in a case like this, they would have professional obligations not to. They can't kill a patient, and they would have to. This was the big tension in the case of Burke, because Mr. Justice Mundy's judgment in Burke seemed to suggest, and this is why the Court of Appeal was very keen to knock this idea on the head, that patients' wishes and autonomy were paramount, and that what patients wanted, they have to get, and that's clearly not what Mr. Justice Mundy, he then was saying, but that's how the judgment could be read. And so the Court of Appeal just wanted to say, no, it's important to assess what patients' wishes are, but they're not determinative. And when we look at paragraphs 50 to 55 of the judgment, we'll see how that relates to life-sustaining treatment, because that's where the real issue is. That's what the judgment in Burke was really about. And so all the broader principles, which the Court of Appeal was very keen, shouldn't cloud that, and needed to be knocked on their head, because the judgment in Burke seemed to be making principles of general applicability to all sorts of medical treatment, and there were dangers in that. But life-sustaining treatment is a special category, as we will see. It's a special category because it engages Article 2 obligations on the part of the state.
So the answer may be life-sustaining treatment is a special category. Outside that, where a doctor says, well, whatever the family think, whatever this individual would have thought had he had capacity, this drug will not do what they think they're going to, that they want done. That's something where the doctor can make a clinical judgment and the Court of Protection won't get involved, or is that not the case?
Well, it may get involved if an application is made, and it may be dealt with very quickly if the matter is very clear that there isn't any particular dispute.
So the permission filter in that context would be the opportunity, really. The sort of extreme example that the law has postulated. Someone who insisted on bleach being given to their incapacitated adult. Doctor saying no, they could make an application to the court, but they would lose the permission stage.
Yes,
Is that how it would work, you think?
that may well be how it works. And of course, that doesn't raise the issues under Article 2, because it isn't an Article 2 case. Except that, of course, it will be a defence for the doctors to say, look, we've actually got an Article 2 obligation not to give you poison to hasten your death. The important, and this is a small bundle that I've handed up. Unfortunately, we didn't include Section 5 of the Medical Capacity Act. But this is important. Section 5 protects someone from liability providing they're acting in compliance with the Act, and that means taking into account best interest. So if someone reasonably believes that what they're doing is in the person's best interests, then providing they're complying with the Act and taking best interests into account, then there's protection. And in the case of Bland, and this is how Bland, of course, preceded the Mental Capacity Act, but the principle was the one that was then embodied in statute. And a lot of the cases that we see, doctors must bring applications because they're concerned, and this is also the value of the declarations that they obtain, they're concerned that they need to be acting lawfully. And where there is doubt, the value for the trust of having a declaration is it will give them effective immunity from civil and probably from criminal liability. And that's something that this trust, having decided not to bring these proceedings, doesn't have the benefit of. They're exposing themselves to serious risk. And we'll see that it appears that they unfortunately relied upon the advice of what would seem to be an unqualified doctor, gave very specific legal advice on the steps that they have to take. It's very unfortunate.
Is that the reference in one of these second opinions to? Yes.
So we'll be looking at.
Well, I that's caught my eye over the weekend was typical advice, so I should want to hear your submissions on that.
And we say this isn't in fact a second opinion because that doctor wasn't asked for a second opinion. The doctor was asked for advice on what they should do, and she proceeded to give very detailed advice on how to avoid the court of protection getting involved. And it's rather disturbing advice, we say. And it's a reason this court should, because it may be that trusts are now turning to these sort of advisors that the court
For my
makes.
part, when we get there, I should want submissions from all parties on that document.
Yes. My lords, my lady, the third of the Strasbourg authorities is the case of Guard in the United Kingdom, which will be at tab 40. Starting at page 1329. And that repeated the principles that were set out in Lambert. So probably don't need to go into any detail on that, but it affirms the principles in Lambert. The Lambert was a Grand Chamber decision. This one wasn't. Turning to ground 1B, which is how the domestic courts have adopted the approach, and this is about ensuring access to the courts. And we say that the domestic authorities recognise that the jurisdiction of the courts arises when there is a dispute of which the court is seized. And at this point, the court needs to be able to resolve the dispute. And if I could take the court to the case of an NHS Trust NY, this is a Supreme Court decision at tab 25 of the authorities bundle, starting at page 873.
This is Lady Black.
Yes. And I've set one of the passages out. This was a case where the court had to decide in cases where clinically assisted nutrition and hydration was to be removed from patients, but where there wasn't a dispute, whether it was still necessary to go to court.
This case was seen originally as reducing the range of cases, the number of cases which would have to go to court.
Yes. Because at the time of Bland, the cautious approach was all these cases needed to be referred to court. But the court in Bland had said once the body of practice builds up, maybe that they don't no longer need to go to court. And so the question was, have we reached that point where the body of practice is built up, where these cases, and there are cases involving life-sustaining treatment, this is to withdraw people's food and fluids, they're not going to live very long. Do these cases need to be brought before the courts? No dispute. These are cases without any dispute. And the court said, no, it's not necessary to. And Lady Black, at page, so this is at 25, and at page 911 of the authorities bundle. Paragraph 109. This is about the third factor. We looked at the factors before. The third factor that features consistently in the European Court evaluation is the possibility of approaching the courts in the event of doubts as to the best decision to take in the patient's interest. And of course, that possibility exists in this country, as Mr. Justice Peter Jackson said, in Rien, incapacitated person. Those considering withdrawal of CANH should not hesitate to approach the Court of Protection in any case in which it seems to them to be right to do so. The opportunity to involve the court is available whether or not the dispute is apparent and there's a particular benefit where the decision is a finely balanced one. No one would discourage an application in any case where it is felt that the assistance of the court would be valuable. And then this is the important sentence for our purposes. And if a dispute has arisen and cannot be resolved, it must inevitably be put before the court. You say that's very clear. So if it's a clinical decision, then it doesn't matter that there's a dispute. No, any dispute has arisen that cannot be resolved, it must inevitably be put before the court. And then at 125, paragraph 125 on page 915, this is concluded.
Court application can and should be made. She says she reiterates the same point.
Yes, the possibility of approaching court in the events of doubts as to the best interest of the patient is an essential part of human rights as well. This is, there was a part of the Guard case which I did want to look at, because I said that the UK courts have gone beyond, so I'm sorry if I take the court back, but I'll go straight to the relevant paragraph, and that's 96 on page 1350 of the authorities bundle. Tab 40. So this is about the third element, the possibility to approach the courts. The third element is the possibility to approach the courts in the event of doubts as to the best decision to take in the patient's interest. It is evident from the domestic proceedings that there was not only the possibility to approach the courts in the event of doubt, but in fact a duty to do so. And that's the important point. There's a duty to do so. So this is where the UK goes even further, we say.
Well, that's what the European Court is saying. They understand the English position to be. So whether that takes us further from what Lady Black said, I'm not sure.
Well, and what I'm going to take what I then can refer to is the BMA guidance, which is the relevant part of the BMA guidance on page 452 of the authorities bundle. So this is on page 452, the final paragraph there. So this is a section about applications to the Court of Protection. And this says, where an application to court is needed, proceedings should be initiated and funded by the relevant NHS body responsible for commissioning or providing the patient's treatment. In England, this would be the NHS Trust or the Central Care Commission Group. And we see the same point set out in the Vice President's practice guidance.
Just pause a minute. Does that actually tell you anything? It says where an application to the court is needed, well, the NHS must pay for it. That's not telling you where an application is needed.
As we see in Re Y, it's wherever there's a dispute.
Well, I quite follow that you rely on that case, but this doesn't seem to add anything.
When I get to grounds 3 and 4, I will show why the applications are needed because it's the best interest decision. I take my Lord's point. I just wanted to show that it wasn't just Strasbourg saying that this is what the UK requires. In fact, it's what we've got various domestic documents and practice guidance and medical guidelines, which also suggest that it has to be it should be the trust in these proceedings, because in this case, of course, it wasn't. And there's also an authority which
Before we go on, all of that is in a section of this guidance, which if one turns back one page, which is under a heading, Managing Disagreement and Uncertainty about what the best interests of the patient, what those interests are. And then there's a quotation from Lady Black, from I think that you've already taken us to, and it's in that context that the paragraph you took us to is set out. So it's all in the same territory.
yes.
Sorry, I interrupted you.
The only other, I make brief reference to a case my Lord Justice Baker asked us to consider, which was a decision by Mr. Justice Hayden called GUP and EUP, 2024 decision of the Court.
Well, I mean, you're going to deal with, are you not, the code of practice in a minute,
Yes,
and you're going to deal with the guidance given by Mr. Justice Hayden when he was the Vice President
yes,
about serious medical treatment cases pending the anticipated redraft of the code of practice, which is still awaited. And again, I thought GUP might come after that, but
well, I haven't very much to say about that, except, well, I'll say a little bit after that, then when we look at.
yes, I mean, the other parties refer to a decision of Mrs. Justice Henke, and I think a decision of, or at least a phrase in a decision of Mr. Justice McKendrick.
Yes.
It goes to, it takes a different position. So it suggests that there's an element of disagreement amongst first instance judges about the clinical decision issue.
Yes,
But maybe you're going to deal with all this under grounds 3 and 4.
yes, I hope to. And I certainly say that any suggestion that there's a privileged category of decisions which are exempt from the requirements of the Mental Capacity Act, it just simply has to be wrong. And so in as much as any first instance decisions suggested that they're incorrect. So those are my submissions on ground 1A and 1B. We've done ground 2. Grounds 3 and 4 I propose to take together because they overlap to a great degree. But I wanted to look at this point at just some elements of the medical or the factual background which are relevant to this case, including the letter from Dr. T, I shall call her, which was giving the advice to the trust as to what they should do in order to avoid getting caught up in court protection proceedings. The evidence before the court is limited to was limited to 2 witness statements in the various attachments, including that letter. We have a witness statement of the appellant, LT, in which she recounts, and this is unchallenged, a conversation she had with various treating clinicians, in which they explained the reasons that they weren't prepared to treat. And we also have a letter from a witness statement from Dr. D, who also makes clear statements of the reasons why the trust was not prepared to treat RB. And we say that when we look at these reasons, and this is the only evidence that was before the court, so we have to accept these on their face. They're not compatible with the submissions made by the trust. And they're not compatible because they clearly show that the reasons which were invoked were best interest decisions. They weren't clinical decisions, even if such a category of decision exists. And it's not compatible with submissions that the trust has made. And the trust has tried to develop or it tried to develop a criterion by which one could establish whether a decision was a clinical one or not. And they said, if it's a decision which would also be made in respect of someone with capacity, then it's not a decision which could come under the Mental Capacity Act, because the fact that the person doesn't have capacity isn't relevant to the decision that they made. And they're saying, well, this decision not to treat would also be made if RB had capacity. And we say, when we look, in fact, at the evidence of the D, that just simply isn't the case. And perhaps if I could also talk to turn to this evidence now. It's at tab 12 of the supplementary bundle. And if we look at paragraph 12 on page 84 of that bundle. So here we go, starting at 11, when we say, applying national guidance and established clinical principles, the treating team has made a clinical decision that ongoing dialysis is not appropriate treatment to offer in RB's situation. The decision is based on the following points. Then 12A, irreversible terminal neurological condition. There is no realistic potential for improvement, and continuing burdensome life-sustaining treatments cannot achieve the intended goals of intensive care. And we say this is, first of all, it doesn't make any sense to say that the treatment would also not have been provided if he had capacity, when they're saying there that it's precisely because he doesn't have capacity that the treatment, the first reason that they give for why the treatment isn't given. So that argument simply doesn't hold any water. I should also say, and this is an important point when we get to the letter of Dr. T, that's the advice letter on how to avoid court of protection proceedings, that Dr. T is a specialist in neurorehabilitation. Dr. T is not a neurologist. Dr. T doesn't appear on the face of the letter to have been asked to diagnose RB, yet she went ahead and did so. And she came up without having examined RB, and without, as far as we're aware, having, but may be wrong about this, having had the benefit of seeing any scans, came up with a diagnosis of this T-doc. She says, we'll look at her letter in a moment, she says that it's not, that the trust has got the wrong diagnosis, it's actually T-doc. It's concerning to me that a clinician is making this sort of diagnosis in a letter in which he wasn't instructed to, it would appear, to make such a diagnosis. It's also concerning that the trust then relies on that diagnosis as a reason for not providing treatment. But anyway, we see there neurological condition, then we see B, dialysis cannot deliver a meaningful benefit for RB and cannot improve or reverse his neurological condition. So again, how can it be that if he had capacity, i.e. if he didn't have a neurological condition, that the same decision would have been made? And then on C, we see burdens and harms, again, classic best interest territory. And then D&E, other considerations, again, impairment, because of his profound and irreversible impairment of consciousness, they're not going to offer the treatment.
You say this is a clinical decision guided by best interests in accordance with the
National guidance.
Council of Europe guidance.
National guidance and established clinical principles, and then they list the whole set of reasons, which are classic best interest reasons as to why the treatment's not going to be given, with the exception, and what's missing from this consideration, it's very important omission, is consideration of RB's wishes and desires, which is the central issue which treating clinicians need to take account of. They don't have to go along with people's wishes, but they have to know what they are and factor them into the decision. But we don't see that there. And then we see at, if we look at paragraph 13, we see reference to, I don't need to take the court to Dr. E's second opinion, but we see there at 13 that Dr. E also says, we do not believe it would be right to offer a treatment to support someone where deterioration and complications are inevitable, starting from a very low level of consciousness. So again, the fact that he doesn't have capacity is the reason that this treatment, one of the reasons it's not indicated. So again, it's simply a hopeless argument to say that the same decision would be made if RB had capacity, when what the treating clinicians and second opinion doctors are saying is quite the opposite. What I would like to take the court to, this is an important point, is the second opinion of Dr. P, who's an intensivist, and his opinion letter is in the supplementary bundle on page 127, tab 14.
All of these second opinions, so called,
Were dated from October or November.
Yes.
So some 4 months before the decision was taken.
Yes.
On the 6th of February. 3 months.
Indeed. But what I would like to take you, Dr. P, right at the end, his conclusions, recommendations, and his fourth recommendation, number 4A in particular, he says, page 134, my opinions on the neurological and renal prognoses are provided as an expert in both neurocritical care and critical care nephrology, but might be supplemented by other expertise. And this is where he says, A, it would be useful for a suitably qualified neurologist who meets the criteria for an expert PDoc physician to formally document that criteria for establishing a permanent, minimally conscious state now exists. The family arranged their own second opinion on neurology. Any expert instructor should meet these criteria. The family did try and they obtained a second opinion neurologist, but were effectively blocked by the trust from being able to instruct them. He was never instructed. We don't have any neurological opinion here. And the significance of this,
Was there ever any assessment, forgive me for interrupting you, Mr. Quintana, was there ever an assessment of capacity applying the WIM or the SMART or those sorts of capacity assessments? Which were, and maybe they're not used as frequently now as they were a few years ago.
Well, they are still used. I'm involved in a case at the moment where we've just commissioned it at the court's invitation, a SMART assessment. But the SMART assessment and the significance of the SMART assessment is that it's made over a period of time and over a period of visits. So the SMART practitioner will have 10 or 12 visits over a period of weeks to assess the capacity of a person or their responsiveness. And the principle being you can't do this if you just visit the person once. You have to, when people have injury to the brain, it may just happen that the time when the clinician turns up for the assessment is the time when
Is capacity still assessed commonly by reference to tests such as that, or are there now other methods for assessing capacity which don't require that degree of labour-intensive work? For example, is scanning now used?
Well,
more?
no, my lord.
Do you mean consciousness rather than capacity?
I do apologise. I do mean consciousness. My mistake. I apologise.
The
Sorry.
I'm not aware of, my lord, I'm conscious it's not my position to give evidence on this. I'm not aware of that scanning can replace smart or whim assessments that often take place.
Anyway, what assessments of consciousness were carried out here?
I'm not aware of any assessments. And this is one of the disturbing aspects of this. The family were only provided, despite the fact that they'd arranged for mediation, which was the start, in fact, on the 13th. Originally, it was the mediation which had been arranged for the 13th of February. They were only provided with the medical records on the 11th of February. They'd been asking for them for a very long time because they wanted to get their own opinions. And it's a matter that the judge below criticised the trust for, in my submission, quite rightly so. It's a feature, unfortunately, that repeats in a lot of these cases where there simply isn't collaboration between trusts and families. And it's most unfortunate because it leads to matters coming to court which maybe won't need to. And I should say at this point, my instructions are very, very clear, that the family is very realistic in its approach in this case. They're not seeking to preserve life at any cost. They just want to be sure of what the situation really is.
Well, how do we know? There's an assertion that he's in something called a TDOC. What's the evidence of that?
Well, the TDOC evidence, the only evidence is Dr. T's assertion that it was. I'm not aware of, until Dr. T's told the trust that they needed to change their diagnosis, then people were acting on the assumption that it was a PDOC situation.
What's the evidence he was in a PDOC? So just so I'm clear,
Well,
others aren't very clear.
there is
Long disorder of consciousness is now the title given to the range of disorders of consciousness, encompassing what used to be called the vegetative state and miliary conscious state.
yes.
Not coma. Not coma, so it's those. And what is the evidence here that he is in that state?
I haven't seen that evidence. My lord, it certainly wasn't before the court. What there is, and this is before the court, and this isn't being proffered as medical or expert evidence. It's just evidence of correspondence between the parties. But I would take the court to it. Again, for proviso, I'm not making submissions that any of this is true, but just to show the sort of things we say that need to be considered. The family and this is on tab 20, page 171 onwards. But I'd look at page 174. The family contacted a professor of neurology and handed that professor what evidence they had. And you'll appreciate they had very little time to do this. And there's certainly no time to instruct any experts. But at point 3, the professor says this. He says, I would like to see recent EEG, as one of the possibilities is that he could have a degree of locked-in syndrome, partly because of the lack of global ischemic changes, but also that the CT on the 17th of April showed a left pontine infarct. MRI did show the left pontine infarct and had extended further back to 22nd of April. Now, this doesn't mean very much to me, but what locked-in syndrome means, as the court will be aware, is that someone does have consciousness, but is in fact locked in, isn't able to communicate with the outside world. And this is a possibility that a professor of neurology who's been shown the medical evidence which exists came to. And this is the sort of evidence which the trust, if it had been in discussion, in meaningful collaboration with the family, would have been able to explore. And of course, if RB does have Lupton syndrome, then it's a horrific prospect what he's being subjected to. If he doesn't, and in fact there isn't any hope for him recovering his consciousness, then the family are going to be realistic about the situation. The instructions have been given. There just hasn't been the possibility to explore this. So perhaps we can look at the letter of Dr. T. This is the letter about how to avoid going to the Court of
So
Protection.
you chose Dr. P's, I'm following this, it was Dr. P's proposal that prompted the trust, you surmise, to go to Dr. T, wasn't it?
No.
Oh, sorry.
Because I can't surmise that, and I don't know. But when we look at Dr. T's letter, which we will do now, there's nothing there about I've been asked to diagnose this patient. I've been asked to give advice on how we should proceed and what steps we need to take.
Sorry, was there anything done in response to Dr. P's proposal to get a disorder of consciousness opinion that you know about?
No, the witness statement, LT's witness statement explains what happened, how they got a neurologist and how they were then stopped from letting the neurologist come. The trust said that they couldn't have someone from outside the trust examine, they would instruct the neurologist themselves, and they never did instruct the neurologist. So they had a neurologist waiting, family was presumably prepared to pay for the neurologist as well, but the trust said, no, we have to do it, and then they didn't do it. So there wasn't, as far as the family is aware, any neurological assessment. And again, it's a very concerning aspect of this whole proceeding. But once they received the letter from Dr. T, that's probably why they felt they didn't need to get a neurologist. And so I would like to look at that letter.
So I completely got it wrong. Rather than following what Dr. P had said,
Yes.
and getting Dr. T, on getting Dr. T, they decided they didn't need to follow what Dr.
Well,
P. Is that
Dr.
what you
T,
said?
Dr. T isn't a neurologist,
I know.
so that's not who they should have gone to.
No.
They should have gone to Dr. C, which is the one that the family had found and was prepared to. So the letter of Dr. T is said to be a second opinion letter. We say it isn't. It's a very old letter. So it's headed without prejudice, but obviously there isn't any legal professional privilege attached, and even if there was, it's because it isn't from a lawyer, and even if it was, it's been waived by having been passed to us. It makes reference to another letter. So this is on page 138, tab 16. Page 140, top of page 140 says, I've sent separately advice on 10 steps to follow, but I'm not aware that we've
Have you
done
seen that?
I haven't seen
I was wondering whether it was.
haven't seen that letter. But what we do see on the first page is this. The second paragraph from the bottom says, you have asked me for advice regarding the clinical decision-making process for withdrawal of treatment in line with the National Clinical Guidelines.
Have you seen the letter of instruction?
No, we haven't seen
Assuming there was a letter.
we haven't seen that.
In the previous paragraph above, it also says the clinical team from the ICU is in agreement that further treatment is futile and clinically inappropriate. Do we have something which distills that?
Well, it certainly wasn't before the court
Okay.
as evidence. I mean, 5,000 pages of notes were given to the family, and they had to rush to make an application. And they made an application on the 13th. It was made late in the afternoon, but during opening time, it wasn't dealt with. It went to the out-of-hours judge, who then criticised the family as unfairly for having delayed, and therefore said, because the family's delayed, we're not going to deal with it. And that isn't how, in my respectful submission, the court should act, because even if the family had delayed, which they hadn't, we say, it was still incumbent on the court to deal with it. and it was pushed back, the hearing, for the following week. But anyway, be that as it may, if we look at this letter, what I'm concerned about are the 9 points, some of the 9 points on page 140, which are the key points.
Before we get to those, was the other key points? I hadn't actually looked at the first page. Would you mind if I just read the first page?
Yes.
Because and the second page, on what basis did Dr. T express the opinion of the first sentence on the second page? I confirm that sadly RB will not regain consciousness. On what clinical, use the word clinical basis? What was the evidence that she had to make that decision?
My lord, I share your perplexity. I don't believe, I'm not aware
I'm
that,
only asking.
well, I'm not aware that she was in a position to make that prognosis, and it's very concerning that someone of her experience did so. And one wonders how this is in compliance with her professional obligations, but that's a matter which we don't need to deal with today. But I am concerned. I'm concerned also.
Well, I don't want to labour at this point, or anything, right? I don't know what it is. But is this? You told me there's no evidence. You don't know what the evidence was on which the conclusion was reached that he is in a disorder of consciousness. Is this the opinion on which the hospital relied?
Well, certainly when we look at Dr. D's, when we look at paragraph 12, where he says that RB has TDOC, then this is the only reference we've got to TDOC, and this is the first time it's appeared, is when Dr. T has said, look, you've got it wrong, it isn't PDOC, it's actually TDOC. This is a progressive degenerative brain damage, for example, due to dementia, Parkinson's disease, or multiple strokes. We say there wasn't any basis for her properly to make such a diagnosis. But it's not clear that she is asserting matters without not having seen the patient, and it's not clear what medical evidence she was provided. She's making
Did she have Dr. P and Dr. E's reports at this point?
I simply don't know. Maybe
They had seen the patient. Both of those doctors, Dr. P and Dr. E, examined RB at the bedside.
I believe so.
She doesn't refer to it
She
at the end of the
didn't.
letter.
She didn't.
No, I'm sorry, she doesn't refer to what she had been given at the end of her letter.
No. But it doesn't, I mean, to be fair to her, she writes without prejudice at the front. It seems she is considering that she's giving legal advice rather than she's making medical statements, but it doesn't seem to be the principal purpose of this letter. It's about, she's asked for advice, she says, regarding clinical decision-making process and how the hospital complies with the guidelines. And it's in the process of explaining that she then opines on various matters that we say she almost certainly shouldn't have.
When did RB lose consciousness? I know that's a sort of lay question. I'm asking to just test for myself the assertion that it's a TDC and not a PDOC.
Do you want me to help you?
If Mr. Patel's got a quick answer, yes.
When he was admitted to hospital, prior to being admitted to hospital, he was unconscious when he was
Yeah, he was,
admitted
that's
to
my
hospital.
understanding. He had a stroke, it was thought, and he was unconscious from that point.
Yes.
So why isn't that, and this is maybe the officious bystander at this point, not the pure judge, but why isn't that a sudden onset acquired brain injury consequent upon a thrombosis? So therefore, why is it not a PDFC?
Well, the prolonged disorder of consciousness can
Well, in her definition, going down that page, PDOC requires sudden onset brain injury which patient may or may not regain consciousness. TDOC, towards the end of life, in patients with Parkinson's, etc., is different.
well, people
And if he had,
people who have strokes, and again, I'm hesitating to give medical evidence, but people who have strokes have oxygen deprivation to the brain, suffer brain damage as a result, and may, in an extreme situation, end up in a coma or
yes,
brain dead or persistent vegetative state. That doesn't mean they've got a degenerative brain damage. That isn't degenerative brain damage. That's caused by the stroke. We don't know what the cause of RB's injury is.
no,
Is it
so I'm just querying why it's TDOC, why she's confident it's TDOC as opposed to PDOC.
She seems very confident about a lot of things. my
Ms.
lord.
Patel will enlighten me.
She seems very confident about a lot of things, and we say this was a matter that certainly when the family approached someone who is competent, someone who is a neurologist, not a neurorehabilitation specialist, that professor said, look, there are signs this could be locked-in syndrome. That's certainly not something she considered. We don't even know if she had the scans of the information or I hesitate to say this, but we don't know if she had the competence even to make that sort of assessment. We're very concerned by what's written.
Well, I've come across Dr. T in other cases, and she clearly, she has given advice, as I recall, some years ago. Anyway, your point is, she wasn't instructed to do that in this case, and yet she gave an opinion.
She gave an opinion, and we say it isn't an opinion which could properly have been given on the basis of some paper information without properly having assessed the patient, and that wasn't. But we're also then concerned, it's understood, with the legal advice that she then goes on to give. That's the medical diagnosis and prognosis that she makes. She then gives her advice in her 9 points, and that's the advice about there being a difference between clinical decisions, which she says are not subject then to review by the court, and best interest decisions. But then she says at point 9, and this is, because this is, my learned friend has now, well, obviously upon instruction, he's making similar points, but it says this: if there is a continued dispute about a decision not to offer treatment, then the family may make an application to the courts. Well, we see that that's not in fact what the BMA guidance, and we shall see that's not what the practice direction of the Vice-Chancellor says. But such disputes are normally dealt with by the administrative court by way of a judicial review. Well, the authorities are few and far between that suggest that that is a normal practice, and I'll deal with judicial review presently. We say that is simply not the adequate remedy in these circumstances. The treating organisation should inform the family of their legal rights, but is not under any obligation to bring the case itself. Well, I'm not sure how a public body can bring judicial review proceedings against its own decision, but that's the legal advice she gives. It then says, she then warns about clinicians muddling language. It says, look, you said from your notes that you're not offering the treatment because it is not in the patient's best interests. As soon as you do that, any dispute about it becomes a matter for the Court of Protection and should be referred by the trust without delay. So that the suggestion is don't do that. My understanding from our discussion is that you're not prepared to offer further treatment because it is clinically inappropriate. So you need to reconsider your language to determine whether or not you've recorded this decision accurately. And then she goes on to give advice on mediations. And the family was trying to organise a mediation, but now we hear that this wasn't going to be a bona fide mediation that was being proposed, but it was something called, it was a facilitative mediation, where basically the family was going to be brought into a room and told what they had to believe. And again, that's concerning, because the purpose of mediation is not to bring, family doesn't need to go through a mediation process to be brought round to a way of thinking. Mediation is to decide what's in the best interest of a patient, and for people to share their intuitions, their ideas, their expertise, and not for people to be channeled into one way of thinking. But that's my concern about the letter of
If there's guidance, isn't there, that where there is a dispute between clinicians and the family, there should be an attempt to resolve it by alternative means without litigation, isn't there?
There is.
I was just trying.
And
Is
mediation.
it in the code? Is it in the code of conduct? I mean, I assume it's taken.
There are a number of authorities. I believe the president of Family Division. I haven't got the case at the top of my head, but where it's very, very much encouraged. But unfortunately, and I was at one mediation myself where we walked in to the mediation and we were told, this is the trust position, we're not going to budge 1 millimetre, take it or leave it. And that, frankly, was a waste of time for all concerned. But it seems to be what Dr. T was proposing, what she calls a facilitative mediation, one in which the family is going to be brought around to their way of thinking. And we say that's not probably a very useful exercise for anyone in these circumstances.
I don't know if this matters or anything, but is that quite what she's saying? She's saying that the type of facilitative mediation that's usually offered won't be effective, as it requires that the treating team would be open to some sort of midway compromise. So she seems to think that a facilitative mediation would involve being open to a compromise.
Well,
it doesn't really matter, does it?
It doesn't. What matters is that she's suggesting, and now I need to get to this for my grounds 3 and 4, that there is a category of decision making which is immune from supervision or protection, but maybe is suitable for the administrative court. And I had it in my skeleton argument that I can take the court to it, but I wanted to start with Lord Lowry in the case of Bland, where he warned. And the question for the courts was, look, is it appropriate that these applications are made to the court? And this was a ground-breaking case where these applications were made. And Lord Lowry says, and it's at page 621 of the authorities bundle, 15G, 3, and he says, procedurally, I can see no present alternative to an application to the court, such as that made in the present case. This view is reinforced for me when I reflect against the backdrop of your Lordship's conclusions of law, that in the absence of an application, the doctor who proposes the cessation of life-supporting care and treatment on the ground that their continuance will not be in the patient's best interest will have reached that conclusion himself and will be judged in his own cause, unless and until his chosen course of action is challenged in criminal or civil proceedings. And that's what courts were keen to avoid. And this is why this declaratory jurisdiction, which the court established in Bland, or affirmed in Bland, the House of Lords, was later codified into the Mental Capacity Act in order to address this risk, that doctors wouldn't be judge and jury in their own case, and also wouldn't expose themselves to challenge in criminal or civil proceedings. And the Mental Capacity Act wasn't meant to have lacunae, wasn't meant to have exempt categories of decision, which would raise exactly the same problem that the court had identified in the BMA guidance, and this I would like to take the court to, is look at page 428 of the authorities Bible. This is tab 12. So it says, which decisions are not covered? Covered by, this code of practice relates to clinically assisted nutrition and hydration. So it doesn't apply to dialysis, but we say the same principles can be applied. So they're saying that there are three types of cases where clinically assisted nutrition and hydration is not clinically indicated. So it's simply there's no obligation on professionals to offer treatment, as it says, that they consider clinically inappropriate. And I think this is the source of the confusion. And the three categories, in short, are where, firstly, it's physically impossible to provide the treatment. Secondly, whether the provision of the treatment carries a high mortality risk, so it'd be an unethical treatment to propose. And thirdly, the treatment would provide no clinical benefit in terms of extending the patient's life or providing symptom relief. So someone might be proposing to treat someone who's dying of a heart attack with kidney dialysis. It's not going to help the person. It's not going to prolong their life. And that's a futile treatment. But in this situation, we say none of these three situations, and these are the only ones that have been identified by the DMA and we say they're not exceptions to the best interests test, because what they are situations where it's evidently not in anyone's best interest, and therefore why they're also clinically inappropriate.
What follows if a case comes into one of these categories?
Well, the clinician's not obliged to offer that treatment.
And what follows then in terms of applications to the court?
What would follow then?
Is the trust, in what circumstances, if any, is there then an obligation to apply to the court if the case falls into one of these three categories?
I believe there is an obligation, but again, it would be one where the trust would provide the evidence and say, look, it's just simply physically impossible to provide this treatment. And one of the examples is the GUP case, which
Yes. Am I following this? You're saying you accept that if the case falls into these categories, the trust, one of these categories, the trust is entitled not to take the matter to court, even if there's a dispute with the parents. That wasn't your case.
that isn't my case.
No.
I'd say it is the case if there's a dispute which can't be resolved and attempts, but there's an element of certain element of unreality. I mean, these are situations where people really are at death's door, and it's very likely that death is going to supervene even before the most urgent applications could be made. There's going to be a process of discussing with the family, of trying to explain the situation, of bringing in that situation, bringing people around to the medical inevitability, or perhaps giving the family an opportunity, and this is an opportunity this family didn't have because they were never given the medical records, say, look, we can't do this for you. There's no one here prepared to or qualified to or who's happy to do it, but you're welcome to look for someone else. Here's all the medical records, go and find someone else and we'll facilitate the transfer if you can find someone. That's one of the important aspects of discussions which could be had in this circumstance. So the family wasn't able to do that because they were simply told, right, we're not going to provide any more dialysis, we haven't yet given you the medical records. You've got the families had medical advisors trying to help them. They had a neurologist ready to advise. They had no possibility to bring on board any external help. But in a situation, say, it's unlikely that such a situation, that someone's at death's door, is going to end up in court. These are situations typically where, and again, when we look at Burke, we'll see that where the Good Field deals with the situations where providing hydration to someone who is actively dying may actually hasten death. and so it's completely clinically inappropriate. But we're talking about the very end stages of life.
Just so I'm clear about the implications of this for a case, if the trust says it falls into one of these categories, that doesn't rule out an application to the court. Is that your case?
If in the face of obstinate refusal by the family, they may need to. But it would be a very rare case, which in my submission, simply because we're at the very end of life here. I mean,
Would the trust be entitled to say that, family say, well, we don't agree. We don't agree with this. Would the trust be entitled to proceed then without going to court? Or would the ball be in the parents' case, in the family's case, to go to court? Or would the trust be under an obligation to go to court knowing that there was the dispute?
the Vice President's guidance suggests that the trust would nonetheless have an obligation. Since this isn't I appreciate why it's important that the implications of my submissions are clear. I hesitate to say that there's an obligation in those circumstances.
But if you need to look at the guidance. It's not just the guidance, it's what the Supreme Court said in an NHS trust and why. Those are the governing principles, aren't they?
It would seem to imply that the matter would have to be brought to court. Maybe that is a situation where the judge could deal with the matter. I'm not saying the matter should be dismissed, but could deal with the matter summarily.
It would that would seem certainly an option here, wouldn't it be? If the trust was not under obligation to bring the matter to court, so the family would be the applicant, then the family would need permission, as in this case, and it would then be open to the judge, depending on the circumstances, to deal with it summarily. In the extreme example that we're postulating now, you say this isn't that case.
Yes, the reason for my hesitation is in light of my submissions under grounds 1 and 2. A judge would deal with it summarily, but would nonetheless give permission and then deal with it summarily. There needs to be the access to the court. That's the force of my grounds.
So maybe my point about permission is over finessing it too much. The court could make a summary decision without a full-blown inquiry.
We've all been involved in cases which have been decided over the telephone in a matter of very short, within an hour, decisions are made. And
Can I just focus on the third possibility, which I know you say is not this case, and indeed, as I understand it, the evidence doesn't show that dialysis wouldn't extend life. But the third possibility here is sort of the family who insists that their parent who lacks capacity but is suffering from COVID should be given bleach. Because the bleach would provide no clinical benefit in terms of extending the patient's life or providing symptom relief. To the contrary, it would kill the person. Does the trust have to go to court before they say, no, we're not giving bleach?
Could I throw something in to help you, Mr. Quintana? This is headed when is patients in whom CAN is not at CNH.
That's true.
What is it? Clinically artificial. Is that clinically artificial nutritional hydration? And we're assuming it applies to dialysis. Yours question is that they propose bleach as a life. I mean, it's
access to the courts, my lord. I make this submission, and we don't come across those sort of cases in the law reports. But nonetheless, the price of defending Article 2 or discharging Article 2 obligations on the part of the state, and indeed the price of defending our freedoms, necessitates that that this possibility is given to people, even to make these sort of applications.
Well, of course, the possibility of somebody making the application is different from saying that the trust has to make the application. So in the bleach scenario, okay, maybe a member of the family can make the application and say it really is in my parents' interest that they be given bleach. But does the trust have to go to court to say, can we please not be ordered to,
Well,
not required to give bleach?
Well, maybe I'd adjust my submissions this much. Neither REY, nor the Vice President's guidance, nor the authorities that they are, say that there's an absolute obligation on the trust. It's saying they should, and in normal circumstances, this is what would happen. I would accept that in these sort of situations, there isn't an obligation. But in these sort of situations, and remembering that one of the important reasons that the trusts do need to go to court is to protect themselves, to protect the clinicians.
But that's
They
a matter
will
of
be-
self-interest.
Well,
That's slightly different.
Well, that was identified in Bland as an important reason for why these declarations have to be made. It gives the doctors confidence to be able to offer treatment without being concerned that they are then going to be liable in any way whatsoever. And in a situation where some absurd treatment is being insisted upon by a family, or some treatment which is self-evidently harmful, I'm sure the trust and the clinicians won't have any concerns about being subject to any sort of regulatory, civil, or prosecution action in criminal courts. It's simply, in those situations, it would be quite proper for them, especially when we're dealing with one of these threshold of death cases, as opposed to end of life case, that they're not going to waste their time with making an application. I'd accept that would be a situation where it would be appropriate for them not to. But nonetheless, the possibility of making the application is necessary, and that maybe would fall on the family's shoulders in those extreme circumstances. But I mean, we often hear about a phrase which has become quite popular in the courts, or in some judgments, is this talk about extending the process of dying. And somehow we're not preserving life, but we're preventing the process of dying from being extended. But if we're talking about the case, and we look at Burke, we see that particular example that the Court of Appeal was dealing with as an exception to the principle that courts are obliged, looking at the principle of which they reject in this case, of patients being able to oblige doctors to treat. This is a case where the provision of the clinically assisted hydration is in fact hastening there. So it's not just that it's neutral, it's actually hastening there. And this is where people really are at the last stages of death. And in my submission, talking about not offering a treatment because it's prolonging the process of dying, and in a situation where someone may live for many, many months, is not giving due respect to the principle of sanctity of life. We had a case a couple of years ago involving dialysis, in which a case called ST, which went to the Court of Appeal. It was a case where there was capacity disputed over a young lady who wanted dialysis, and the trust didn't want to give it to her. But her process of dying went on for a whole year. It simply makes no sense where someone is in a long-term, maybe degenerative situation, but where they may live for many months, to say that no, we're not actually intending for you to die when we remove this treatment, we're just prolonging the process of death. This makes a nonsense of the principle of sanctity of life, and it's not the BNA guidance.
No, I'm just becoming concerned about time. We've saved you up a good deal, but Mr. Patel and Ms. Watson will need their time. So really, it would be beneficial if you could wind your submissions up by 1 o'clock.
Yes, my lord. Great. So I want to make just a submission on, just very brief, discrete submission on judicial review as an alternative remedy in these sort of cases, because this is what's being proposed. And we say judicial review simply isn't an appropriate remedy. It's a remedy of last resort. Parliament, in its wisdom, has set in place a detailed and comprehensive legislative scheme in the form of the Mental Capacity Act, which is to deal with these questions. It set up a specialist court which will look at the fact-sensitive and highly individual situations which are presented to it. And all these matters are simply not matters which are appropriate for consideration by the administrative court. It's very rare that the administrative court will hear live evidence or have a chance to cross-examine. And in a case where a court's required to determine evidential disputes, that's a very strong indication that it isn't suitable for judicial review. The cases that my learned friend raises, he mentions 2 cases, the case of Rakib and the case of Abbott. Those were questions which a discrete question of law felt to be considered by
The key was in both courts, wasn't it?
Yes, it was.
Admin court and the court, no, and division.
It was. 2 applications
Same point.
were made, one by the family and one by the trust, and
Yeah.
they were heard by a single judge, family court judge who had an administrative court ticket, and you had the cases contemporaneously. The judicial review case in that case was a discrete question of law as to whether the Treaty for the European Union and the Articles on Free Movement of Persons prohibited the UK from blocking someone exercising access to services in another country. It simply was not a best interest consideration. It didn't require
So
any.
the admin court point was a discrete separate point. It
Yes.
wasn't really used to determine
No.
the
And Rakib succeeded both on best interest grounds and also on the judicial review, but the judicial review ground on which it succeeded was very limited. It was that the trust hadn't considered Tafida Rakib's free movement rights. That was it. There simply was no record of them having sat down and said, well, look, let's put this in the balance. And so they won on the judicial review ground, but in that limited way. And that's precisely how the sort of question that the administrative court will decide. And the other case was about forced feeding of a prisoner.
Was it Haddock or was it Rita
Yes.
Gray?
So there's a question about statutory duties on the body which is looking after the prisoner, and a clear question of whether there's a breach of persons' human rights if they're being forced. I mean, it's a discrete question of law. It's not a best interest question. It's not one which involves the sort of delicate questions and detailed questions which the Court of Protection instead is competent to deal with. So we say that judicial review is as it were red herring, and it's not suitable to resolve these sort of cases.
Did you have any specific submissions on Burke?
Yes. So my submissions on Burke are these, that there's been concentration on paragraph 50 of Burke, which can be found on page 966 of the authorities bundle. And where the Court of Appeal explains the concern that had arisen because of one of the declarations, and the concerns about various declarations. But the GMC, in paragraph 50, is concerned that these passages suggest that a doctor is obliged if the patient...
669, it's not 966.
My apologies.
Sorry. paragraph 50 is the paragraph he's always quoted.
Yes. So there's a concern that doctors, that patients can insist on doctors providing treatment, and then there's a description of this decision-making process. We say there's nothing there. We say, look, the doctor exercising his professional clinical judgment decides what treatment options are clinically indicated. And we say there's nothing there which indicates that best interest mustn't inform that decision. And indeed, when one looks at the Code of Practice, Mental Capacity Act, the GMC guidance, and the VMA guidance, maybe we see, that, or rather, we look at the Council of Europe guidance, we see that in fact even those clinical decisions have to be informed by best interest.
But Merck is about a capacitous patient.
Yes, it is. And I have a submission to make about that. When we look at the following passages, see paragraph 51. The relationship between doctor and patient usually begins with diagnosis and advice. The doctor will describe the treatment he recommends, or if there are a number of alternatives, the treatment that he would be prepared to administer in the interest of the patient. So again, the clinical, the so-called distinction falls apart there as soon as we get to the next paragraph. The treatments he's prepared to recommend have to be ones in the interest of the patient, because he's already had to take the best interest into account. And then again, the last sentence there, in truth, the right to choose, and that's the choice stage, is treatments as a reflection of the fact that it's the doctor's duty to provide a treatment that he considers to be in the interest of the patient. So the treatment that the doctor's providing to the patient already has to be in the best interest, or one in the interest of the patient. It's not that there's a clinical decision which isn't informed by best interest. And that's very, very clearly laid out in paragraph 51. Then 52. Mr. Justice Mundy was not however concerned with the extent to which in general a patient has a right to insist on a particular treatment. He was concerned with the choice of whether or not to receive life-prolonging treatment. And so this, remember the concerns in Burke, but very sweeping declarations have been made which apply to all sorts of medical treatment. And this is why the GMC then got, why various interveners got involved as well, and why the appeal was made. But then we see this, and this is very important, paragraph 53, related to life-sustaining treatment. We've indicated that where a competent patient indicates his or her wish to be kept alive by the provision of A&H, any doctor who deliberately brings that patient's life to an end by discontinuing the supply of A&H will not merely be in breach of duty, but guilty of murder. Where life depends upon the continued provision of A&H, there can be no question of the supply of A&H not being clinically indicated. No question of it not being clinically indicated, unless a clinical decision has been taken that that life in question should come to an end. But that's the clinical decision that can't be made, because that would then expose the doctor would be liable for murder. This is not a decision that can lawfully be taken in the case of a competent patient who expresses the wish to remain alive. And we say that the same considerations apply here. Where life depends on continued provision of dialysis, there can be no question that the continuation of dialysis is clinically indicated. And the only reason it wouldn't be provided is if the patient refuses it. And that's where the role of the Court of Protection, of the court making the declarations, comes in. The court has to look at the best interests and say, the court gives consent on behalf of the patient for the treatment which is being offered. And the court may say, this provision of dialysis is so burdensome that the patient, considering his wishes, is simply not going to give consent to it. And so the court will refuse to give consent to the treatment, and it will be unlawful to provide dialysis. But if the court instead looks at the picture in the round and says, dialysis should be provided, or at least the patient is giving consent to this treatment, then that consent will be given in the form of a declaration. And we say at that point, 53 bites, because at that point, there's no question that it's clinically indicated. We have a clinically indicated treatment that's sustaining life and consent has been given by the patient. The doctors can then choose not to provide dialysis, but they're at a very serious risk, as the Court of Appeal says, of being in breach not just of duty, but guilty of murder. And that's why we say that the declaration that it is in the patient's interests to receive dialysis, the declaration by the court that RB gives us consent, then is sufficient to attain the end we're looking for.
Court of Appeal went on to comment about the obligation to go to court, didn't it? In the latter passages of the judgment.
I just wanted, just as we're on this section, if I may, conscious of the time, just to point out paragraphs 54 and 55, and then 54 says, look, we're looking at a situation where ANH will not be clinically indicated, and this is where the provision of ANH would not prolong life, but even hasten death. Because apparently in the last stage, and the evidence before the court from Professor Higginson was that at the last stages of life, giving hydration to people who, in particular situations, were dying, would in fact hasten their death. And so that brings us into BMA category 2 cases, or 2 and 3 cases, where, but the important point there, if we look at the definition of life-sustaining treatment in the code itself, it is a treatment which isn't necessary to sustain life, isn't defined as life-sustaining treatment. So, whereas normally giving people who can't drink themselves clinically assisted hydration is life-sustaining treatment and is rightly classified as such, in some cases it isn't. It's actually a poison given, and it isn't life-sustaining treatment for the purposes of the code, and the obligations to provide it no longer exist. And what we say the trust is doing, they're saying, look, we can't put RB in a more privileged position than someone who's got capacity, because someone who's got capacity isn't able to insist on a doctor providing treatment. We say that isn't what Bone says. Someone who has capacity is able to make, if a doctor refused to provide them nutrition and hydration, and it didn't fall into one of the BMA 3 categories, they would be able to force the treatment to be provided, and there would be an Article 2 obligation on the state to provide that treatment. I make that submission.
So say that again, would you strike?
When you say that the state can order the doctor to make it?
Well, there's an obligation on the state. The obligation is this. I mean, we've seen the Court of Appeal saying that if a capacitous patient wants to have ANH, and it isn't a situation where it's not clinically indicated because it's going to hasten their death, then a doctor who refuses to provide that's paragraph 53, would not just be in breach of duty, but guilty of murder. Now, how that obligation, how that right that patient has is going to be enforced in the courts, there may be different ways. It may be a case for, in those situations, for an injunction, and the Court of Protection is able to make injunctions. But there are ways in which I say that in this particular case, where because there is a duty on the state, and because there's a breach of serious criminal law and also professional duties, there'll be various ways in which a capacitous patient will be able to enforce their right at law. But what the trust's argument is, far from putting the incapacitous patient in a more privileged position, it puts them in a less privileged position, because they're not even able to express, they're not allowed to go to court to express consent to the treatment. The court is needed to give its, in the form of a declaration, to give its consent for a treatment. And they have to have that possibility. I just wanted, in my last few minutes, very briefly, I've dealt with this in my skeleton, but it's important. We say there's no conflict between the mental capacity code and the guidance, GMC guidance, or the BMA guidelines. If there were, the mental capacity code would prevail, and that's set out in Aintree. I don't need to take the court to that, but it's a statutory code of practice to which medical professionals are bound. I put in section 42 of the Act I've handed up this morning, and that shows that there's an obligation on professionals to apply the statutory code of practice. At 88 of your page 88 of the authorities bundle,
I'm sorry, that was section 42 or?
the Mental Capacity Act.
Yeah, I don't think we did hand that up today.
I handed
Yes,
up,
you did. I'm sorry. Thank you very much. I've got it. That's fine.
so
Sorry, did you say page 88 of the authority?
88, chapter 5, what does the Act mean when it talks about best interests? One of the key principles of the Act is that any act done for, or any decision made on behalf of a person who lacks capacity, must be done or made in that person's best interests. That is to say, whether the person making the decision is acting as a family carer, paid care worker, an attorney, a court-appointed deputy or healthcare professional, and whether the decision is a minor issue, like what to wear, or a major issue, like whether to provide particular healthcare. So again, there's no carve-out for clinical decisions. The clinical decision to provide healthcare in BERT 50.1 is a decision whether to provide particular healthcare, and that's subject to the court of protection. That's subject to that has to be made in the person's best interests, the so-called clinical decision. That's very clearly spelled out in the code, and also in the Act, where we've seen that any decision has to be made in the person's best interest. And then we see next that if they do make a decision in the best interests, they'll be protected from liability. And again, that's disturbing where the trust says that they're not making a decision in the best interest. They're exposing themselves as a result of Dr. B's advice to liability, which they wouldn't otherwise have to have. I don't have time to take the court to any other parts of the code. Just say that the GMC guidance essentially provides the same.
533 is your key paragraph, isn't it? 533. It's 520
Yes.
36. And
Yes. I'd ask the court certainly to read 529 to 536, 5.29 to 5.36.
Yeah.
And then just finally, I'd like to go to the GMC guidance, authorities 10, tab 10, page 323. Is where it starts. It's paragraphs 47, 48, and 49, which are at 341. And this is resolving disagreements. I have half a minute, so I'll just skip straight to 49. And it says this: in situations in which a patient with capacity, so this is about with capacity, to decide requests.
sorry, which paragraph? Sorry, which page?
Sorry, page 341.
My mistake, Karen. Sorry.
So this is dealing with, this 49 is dealing with a capacity issue, but it's important again to show that this so-called clinical decisions are also subject to best interest. In situations in which a patient with capacity to decide requests a treatment and does not accept your view that the treatment would not be clinically appropriate, the steps suggested above for resolving disagreements may also be helpful. And those steps, and obviously the same doesn't apply because they've got capacity, but the steps that what it's showing is that it's the same principle applies in capacity, incapacity, but in incapacity it also, at the end of 48, includes the possibility of starting legal proceedings, and that's against a decision that a treatment would not be clinically appropriate, we say. And again, that ties in with what we've seen in the capacity code, that all decisions, by treatment or not, are subject to best interests. My lords, I realise we've reached the end of time. I should just turn and ask it. My lords, my lady, those are my submissions.
Thank you very much. You've done well to finish by lunch. So 2 o'clock.
Court rise.
So before we go any further, the Lord asked me to deal with an issue. We had an email from Professor Kitzinger, which unfortunately none of us saw before the short adjournment. Professor Kitzinger was watching the proceedings by the live stream. I apologise to her for the fact that we haven't been able to deal with this before now. She raised 3 issues. First of all, the transparency order. She points out that the order that under the terms of the order she's not allowed really to publish anything herself, yet the case is widely published, details of the case are widely published elsewhere, which Mr. Quentivali told us about this morning. So we were hoping you and the 3 of you had a chance to talk about that matter. Maybe you haven't, as we originally proposed, is the first point. Second point is she asked for the skeleton arguments. The policy of the Court of Appeal Office is, I understand, that redacted copies of the skeleton arguments should be made available by the parties rather than by the court. That's why I asked for them, anticipated we might get an inquiry like this, I asked for them to be prepared in a way which will be disclosed. Can I ask that if she's watching, for contact to be made with one of the solicitors and for that to be arranged? And the third thing she asked was the question of the judgment of Mr. Justice Tice. Professor Kitzinger was observing the proceeding before Mrs. Justice Tice, so took a note, but doesn't have a copy of the judgment that we've got. We take the view that that is unredacted, that has names in it. She was proposing it would be available to her for onward transmission, and the circumstances we thought that not appropriate. That's something I think you may say, because it was limited subject to the transparency order, and we think at the moment that any application about that should be made to Mr. Justice Tice rather than dealt with by us. Do you have any comments on any of that?
Well, in relation to the transparency order, we have discussed that during the lunch. I think there's a dispute between my learned friends on either side of the courtroom in terms of whether the transparency order should be relaxed to permit the naming of P and P's family. As I indicated earlier, the transparency order already provides for the naming of the trust. That's not a matter that is restricted. What was restricted was the name of the hospital, but as I said to you this morning, given the similarity between the trust and the hospital, I can't really see how that's a convincing.
Are there Abasi issues that you want to raise?
Are there Varsity issues?
Abasi.
Well, the only Abasi issue is about my clinicians.
Yeah.
Currently, my lord, they are their identity is restricted. I would say that remains. It remains at least until these proceedings are ongoing, but I think also at least until RB is alive, I would say, and then one would then look at
A short period afterwards.
cooling off period. If there are any appropriate Article 8 issues from my clinicians at that point, I would then, in the usual course, make an application to the court to extend the transparency order if those were my instructions.
We think we'll deal with the substantive issues on appeal, then not forgetting the small issue between Ms. Watson and Mr. Quintivani, which we'll do at the end of the day.
Does that
Well,
make
the-
sense?
In relation to skeleton arguments, I'm very happy to give those to Professor
Yes,
Kitson.
I
I mean, that's no difficulty whatsoever. We have all prepared redacted versions of the skeleton
Yes.
argument, so that can be done.
And then the judgment.
The judgment, my lord, what your lordship proposes is, in my submission, very sensible.
Right. So we'll deal with the issue about the transparency order after we've heard
Thank you.
the arguments.
My lords, thank you. My lords, given the circumstances of this case, I've only just stopped drafting the written argument. So it's not one of these cases in which I would have to prepare again in order to make the oral submissions. I have, though, in the short time between finishing the written submissions and standing on my feet, discovered another case which I've put on your benches. It's the ECHR case of Medoune and France. I'll come on to that in a moment, my lord, but the relevant paragraph is paragraph 48, and it's a dicta from the court as to what Article 2 and Article 8 require by way of demanding treatment. It's a recent judgment. It came out on the 5th of February of this year. I should say,
That was paragraph 48.
48.
Thank you.
I should say, my lord, my lady, that that is an unofficial English translation of the judgment. The judgment is only in French at the moment officially.
Is it unofficial? Is it Google?
Yes, well, that's why I called it unofficial. I didn't do it, but someone with much greater technical skills than me put it into Google and produced this document. But
I think Mr. Quintavari speaks French, so he'll be able to spot any particular difficulties with paragraph.
well, I'll leave it to him
Paragraph 48.
to tell me whether the relevant paragraph is a mistranslation.
Wants to read paragraph 48 while we're.
Well, I was going to come to it, but yes, of course. Do.
We're in your own time, that's fine.
Well,
Sorry.
Well, so the way I was going to deal with it was deal first with the evidence. Your lordship had a number of questions from Mr. Quintavari, which I think probably more properly should be dealt with and addressed by myself. Then I was going to deal with the legal structure, because the legal structure in my submission, it has space for a clinical decision as well as a best interest decision. And I would like to deal with the materials, the legal materials, which I say supports that submission.
Mr. Patel, do you say then that clinical decisions are made out with best interests, and that when a doctor makes a clinical decision, they don't take into account the best interests of their
So
patients? I'm just finding
I do to this extent, my
You do?
lady. I do to this extent. What I've termed a clinical decision
Yeah.
is a decision that informs the doctor or the clinician's decision whether to offer any or a particular treatment. Having assessed the patient's condition, having taken from the patient, if they are able to give it, their medical history, having taken from the patient how they lived with the condition, or how they've lived with the condition, what they feel about the condition. It's all about the clinical condition at that point. And the doctor uses his or her professional skill in order to identify how to manage that condition medically. And it may be that there are a number of treatments that he or she identifies, that he or she says, these are the treatments that you can have, or I'm prepared to offer you in order to manage your condition. Now that is the same process in my submission, whether the patient in front of the doctor has the capacity to make decisions about that treatment, or whether the patient lacks capacity. And in fact, that first process, the first process of identifying treatment options, is absolutely critical in identifying whether that patient has capacity to consent to those if they are offered. because capacity is not a general capacity to make decisions about all medical treatment. It is, as my Lord Justice Baker will very readily know, a decision that has to be taken about a particular decision at a particular time.
Decision specific.
And so if the doctor, having assessed the patient clinically, determines that there are a number of treatment options that he would or she would offer to that patient, that doctor then has to assess whether that patient has the capacity to consent to those options. If the patient has the capacity to consent to those options, and then in fact consents to one or a number of those options, that provides the authority for the doctor to provide that treatment. That's the capacitous patient. In relation to the patient who lacks capacity, and again, one goes through the same process with that patient as to whether in fact they have the capacity to consent to that particular treatment or treatments. A decision has to be made. If there's an assessment on a conclusion reached that the patient lacks capacity to consent to those treatments, a decision then has to be made in that patient's best interests. That is a decision which is made under Section 4 of the Mental Capacity Act. My lords, my lady, that's not confined to what the Court of Protection does. It's anybody making a decision on behalf of a person who lacks capacity has to use the statutory checklist under Section 4.
Including clinicians.
Including clinicians.
When decide when reaching a decision, any decision about whatever the phrase is at the start of Section 4. I know we're taking you out of your order now.
No, my lord, of course not.
Section 4 says, in determining for the purposes of this Act what is in a person's best interests.
And my
And
lord
you must consider all the relevant circumstances and in particular take the following steps.
My lord, indeed. And that's to determine whether a particular decision is in that person's best interest, because one has to take that decision in that by reference to best interests at that point. But the decision at that point is whether or not to consent on behalf of the person who lacks capacity to the treatment that is being offered. So if the treatment is not offered because the doctor determines that the treatment, particular treatments, are clinically inappropriate, and what that means in my submission is whether the treatment is it wouldn't be clinically indicated. So in the bleach COVID example, bleach is not a clinically indicated treatment because it clearly doesn't benefit the patient in terms of their condition of COVID.
Just to be clear, there's a sort of ambiguity when we're talking about benefit or best interests or whatever. We saw in the BMA document reference to extending life or relieving symptoms. So how do those criteria compare with being clinically indicated or clinically appropriate?
Well, so if the BMA guidance is about clinically assisted nutrition and hydration,
Yes.
And if one takes that particular medical treatment, initially the clinician has to determine whether, if one's starting off from scratch in terms of that he has a patient who can't swallow normal food and therefore needs to be kept alive by way of clinically assisted nutrition and hydration, the clinician then has to determine whether that's a clinically appropriate treatment. And if he decides it's not, and in favour of deciding it is a clinically appropriate treatment, will be that it would do the job of keeping him alive or ensuring he had enough nutrition and hydration to live.
And continue to take you completely out of your course for a moment longer. So coming closer to our situation, if there is a question of whether a treatment is clinically appropriate in circumstances where it is going to extend life. What will determine whether or not it is clinically appropriate?
Well, that's where the question of whether a treatment is clinically appropriate is a question for the doctor to answer.
And in deciding whether a treatment which is going to extend life is clinically appropriate, does the doctor have regard to the patient's interests?
He has regard to the patient's condition at that stage, and to the extent to which what the benefit is in relation to that treatment by regard to his condition. What he doesn't have regard to at that stage is the sort of best interest checklist that one sees in section 4.
I see the point about the checklist, but if you are addressing a treatment which is going to extend life, but you think it's not clinically appropriate, are you in truth factoring in something about whether you think that's in the patient's interests?
Well, it would be whether it was in the patient's interests. It's just not a best interests analysis. It would be whether it's medically in that patient's interest. And one of the things that's medically in that patient's interest is the thing that would be keeping them alive, treatment. Now, it may be, take an example from the case law that we've seen, the GUP-EUP case, that in those circumstances, whilst nutrition would have been keeping the lady alive, they simply couldn't safely put in a tube so that they could deliver the nutrition. And one then had to determine whether in fact that was clinically appropriate or not in those circumstances. And it's the overall treatment picture that one is looking at in those circumstances, because you're not going to be able to offer artificial nutrition unless you've got a tube through which it goes. In the same way, in this case, the evidence was, and I'm going to come on to that in a moment, the evidence was in short that the central tunneled dialysis catheter, which is the way in which one most safely provides dialysis, that was blocked. It couldn't be used any longer. And it was after that particular event occurred, and having regards to the alternative of providing dialysis, which was through a temporary line, and the harms that would come to the patient in relation to that, that the decision was taken that further dialysis was not clinically appropriate.
Mr. Patel, can you take me one step back, because you're making a distinction, as I understand it, between a clinician considering the interests of the patient and making a clinical decision and best interests. Will you just explain to me what you say the difference between the interests of the patient and best interests?
So I think when I'm talking about the interest, I'm talking about the patient's medical condition.
That was the phrase you used as well. You did use say interest, but you also said condition.
Yes, that's the point. That's the point I'm really making, because
Milady's point is equally valid. What is the difference between the patient's condition and the patient's best interest?
The patient's condition and how to meet it or best meet it, and whether it's possible to safely meet it or properly meet it or appropriately meet it, is a matter for the clinician.
So, is it able to meet it safely?
It could be either safely. It's not safe. I mean, for instance, again, the bleach example would come into that, which would be that here's a treatment that's that someone says you should have for COVID, but it's simply not safe to administer, and so it wouldn't be clinically appropriate. And so we would say
it falls at an earlier hurdle.
It does, but I think it falls at all of these hurdles. That particular example.
But
Now,
it gets more complicated if you're away from bleach for a moment. I mean, if you have a scenario where, say, doing something, whether it's dialysis or something else, in all likelihood will extend life, but there is a risk of death attached to it. Well, if you don't do it, you're bound to die. So I'm not quite sure how far you factor in the risk of death. And underlying it all, is it an assessment of
But-
whether it's in the patient's best interest to be kept alive.
My lord, I'm not sure it's necessarily. It's even more complicated than your lordship's actually postulated, because the evidence is that there were a number of comorbidities that RB suffered from which he could, in fact, die. And that's what factors into the condition that the doctors are looking at in order to determine, is this particular treatment which requires other treatment, is that a clinically appropriate treatment in these circumstances? And of course, the doctors have to determine that not at the beginning and keep it as a static process. It has to be a dynamic process all the way through this person's treatment in person's condition.
And I'm sorry to press you again, but then you say you have to look at all his conditions, and let's make this not the patient in this case, all the person's conditions, and the possible treatments, and they've got to decide what is, and you use the phrase, clinically appropriate. But how do you make that clinically appropriate decision? What do you take into account? I think you've mentioned that you obviously take into account all the variety of different difficulties that the person has, and the variety of possible interventions, let's call them that, and you look at, I think you're saying, what is most appropriate. But how do you make that last leap into what is most appropriate? What are the factors?
Melanie, perhaps let's divorce this from the person who lacks capacity, because
exactly.
if one
This
is
just
dealing with a person who
person.
has capacity, there's no question of best interests at all, because what you're doing as a doctor is saying, this is your condition, this is what I believe is the treatment that is required or would benefit you. It has these risks, and that's all about it's all about your condition and all about the treatment. It won't work in these circumstances. It's not safe in these other circumstances. Saying that, and that's what you explain to the person who's got capacity.
Yes, but the interesting, it is fascinating the difference between a capacitous and an incapacitator, because at that point you give the doctor gives the patient, here are the clinical things, and the patient takes into account the non-clinical things.
No,
You're making a decision.
my lord, correct, but only if you offer the treatment. You may decide that, given all the things that you've just described, that you don't offer the treatment, in which case the patient who has capacity has no right to demand that treatment from you.
Can I just explore that one moment? So suppose you have a patient who has got comorbidities, but those aside has absolutely good capacity. And there's a question of whether or not you make available to that patient a treatment that, all being well, would extend life, but there are risks attached to it which could possibly shorten life. But if you don't give the treatment, the patient will die. Now, you would there offer the treatment, wouldn't you?
No, not necessarily, my lord, because you may take the view that, in your professional view, that the benefit of keeping them alive for a particular period is so outweighed by the harms and the risk of death that treatment might entail, that you think it's simply not appropriate to offer that treatment. So that's what and that's the space I think is
been
open.
provided already, which is the situation we were in here, dialysis, and I know there were complications at the time. This was a patient being provided with dialysis. If he had capacity on the 6th of February, and he said, I want to carry on getting dialysis, the doctors wouldn't have said, sorry, no, would they, in those circumstances?
My lord, no, the evidence is that they would have done, because they considered, and it's the list of things under. I'll come to that in a moment. Paragraph 12 of Dr. D's statement, that's what I meant.
That, but I should be interested to see how that plays out. But so you are saying, are you, that there are this sort of difficult situation where a patient with capacity, the line is blocked. They have one go at the vas cath, doesn't work, and they reach the view it isn't going to work. They would not, even if he said, I really want you to have another go, they would say no. I find that hard to accept, Mr. Patel, I really do.
Well, my lord, it's. Well, I'm not sure anything I say is going to change your mind, but I think
it's a
that
very difficult situation.
it is, and I think
you must recognise that there is a shift here in what in how things are being seen.
well, what I'm recognising is this, which is that is an extremely difficult judgment call to make, and it's it's a but we say it's a professional judgment call because what the doctors have come to, and the view that they've come to, is that they are not prepared to offer the treatment, and this is not a case in which there is one doctor in the hospital department who has come to that view. It is all the nephrologists in that department and in the renal unit.
And we've been diverting you from the evidence. It probably is best if you take us to the evidence.
I've got one. Can I read down with one of those? I'd love to know what is in condition. Is pain in condition? Is mental health in condition? There are all sorts of
Depending on
quite a broad. Where does condition end and best interest? Clinical condition. What a phrase I think you'll find in there. Expressing clinical condition is a valid concept in this context. Where does it end and best interest begin?
Well, again, my lord, that's a matter for the specialist judgment and skill of the doctor.
Judge in their own cause.
Well, they're not judges in their own cause because they have to comply with their professional obligations, which is their professional duties. And I'll take you to the GM's.
One moment suggesting that you anything professionally improper at all with the doctor. These are terribly difficult cases, and doctors wonderful thing.
I'm a little nor as I suggesting that you were, but what I think I am suggesting in this regard is that these are very difficult judgments, very difficult professional judgments for a doctor to make, and the doctor is the person who's making those judgments at this stage. And if at the end of that stage the doctor's judgment is, I simply don't think it's ethical for me to offer this treatment, then that must be the same whether it's a person with capacity and a person who lacks capacity.
And I think we're all perhaps agreed, and we certainly are all agreed about the proper operation of ethics amongst doctors and amongst these doctors. That's not in question. Our questions are intended to try to find whether there is or isn't a line between the kind of facets, the kind of factors which are in that doctor's mind, and you say they're making an interest decision, a clinical decision on the basis of medical condition, and the difference between that best interests and that is still troubling me. Where is that line?
Well,
but you're going to come to that because you're going to take us to the end.
Well, Melanie, let me just answer that briefly now, and I'll develop it later. Which is in my submission, I think it's there could be a judgment call made by that doctor at that point that their risks are such that are not such that they think that it's clinically inappropriate treatment. So but they still have very, very grave reservations about providing the treatment. And therefore, that is the thing that then comes into the best interest analysis, because they say, well, I'm willing to offer this treatment, but am I actually going to provide it because is it in the best interest of this patient? Because the best interest is there to consent to treatment that the incapacitated person can't consent to by virtue of his incapacity. And that then draws a parallel with the person who has capacity, because that's the sort of thing that the person with capacity is going to, the sort of exercise the person with capacity is going to be conducting to decide whether in fact they will consent to that treatment given all the very serious risks that the doctor has explained to you. Dr. D, beg your pardon. Dr. D, the way that the evidence arose before the Vice President was that this matter came on very quickly, and therefore there was no opportunity to sort of decide on vast amounts of evidence. And in fact, LT's evidence came in at exactly the same time as Dr. D's evidence. And so neither LT nor the Trust had any opportunity to sort of contradict each other. in terms of the evidence, but that's where we stood with the evidence. And Dr. D's evidence is at Supplemental Bundle 81. Tab 12. And the clinical position starts at paragraph 4. And Lord Justice Baker asked about when Mr. RB was unconscious. It was when he was found unconscious,
That's right.
having collapsed at home, and he had multiple organ failure. He was then, this is paragraph 4 I'm reading from. He was then admitted to the ICU. He underwent urgent investigations and treatment for possible causes of collapse. And then we have the extent of his brain injury, my lord and my lady. Extensive brain injury. Scanning and imaging showed widespread abnormalities consistent with multiple strokes. MRI imaging on the 2nd of May demonstrated multiple acute and subacute ischemic injuries, again strokes. Further MRI imaging on the 2nd of July showed multiple established lacunar infarcts affecting both cerebral hemispheres, the basal ganglia and the pons, effectively representing a large burden of irreversible brain injury. And then, my lord, since late May 2025, there have been repeated specialist neurological assessments, and they've consistently found no meaningful neurological recovery. And then later on at top of page 83, while RB has periods of eye-opening and reflex responses, there is no reliable evidence of communication, consistent interaction or purposeful behaviour. Overall, there has been no sustained positive neurological trajectory over many months of careful observation and multidisciplinary care. So that was the evidence.
And the next sentence.
Can I come on to that in a moment? Because I know your lord has some concern about the way in which that...
Pausing there, there was a lot of scanning going on and illustrated plainly, sadly, very extensive brain damage. Sorry to dwell on that, but that's the reality. But there wasn't any testing at the hospital of consciousness, was there?
Well, my lord, your lordship asked questions about SMART assessments and WIMS and Glasgow recovery scale sorts of assessments, which are standard, specialist standard assessments. My lord, very much since I think your lordship was hearing these cases at first instance, matters have moved on from there. The PDOC and disorders of consciousness guidance, when one's talking about diagnosis, relies upon clinical diagnosis as the primary observations as the primary matter. Now, these specialised assessments such as SMART, WIM, Glasgow recovery scale, they're all done if there's a particular issue with diagnosis or a particular issue in relation to deciding whether somebody's in vegetative state or minimally conscious state. Your lordship will remember that back in the day, it was very important to establish whether somebody was in vegetative state rather than minimally conscious state, because that determined effectively the decision about whether clinically assisted nutrition and hydration would then at that point be removed. It
would be a factor, because there's a spectrum. There still is.
It was.
PDOC hasn't.
It's still a spectrum.
There's a spectrum.
Still a spectrum.
And it is still in certain circumstances appropriate to know where on the spectrum the patient falls.
In terms of recovery, in terms of their chances of recovery. And my lord, it was important in those days to determine diagnosis carefully, because until your lordship gave judgment, I think it was in W and M, the position was that if you were in vegetative state, the clinically assisted nutrition and hydration would be withdrawn, and if you were not, then there was something in the balance, and then one had to do the exercise which your lordship did. Now that is no longer the position, because now that one has the balance and one looks at it in terms of the balance, one is looking at it in terms of what the prospects of recovery are, and that's a clinical decision primarily, not based upon these specialised tests. In any event, my lord, these specialised tests would not have been conducted in a ICU. They need a specialist environment. Your lordship will remember that.
Are they done? They can be done at the bedside, can't they? Or not? They were some time ago.
They can, I think, be done at the bedside, but that's not the optimum way one would do it. And certainly, I'm pretty sure in the noisy environment of the ICU, that is not something that one would do. So, whilst there aren't any specific specialised tests to establish a level of consciousness, my submission is it wasn't required here. In that regard, what was required was people who knew what they were doing and knew what they were looking for, doing the observations, and then what they found was in paragraph 6. Periods of eye-opening, reflex responses, no reliable evidence of communication, consistent interaction or purposeful behaviour, which puts Mr. RB at the lower end of the spectrum of disorders of consciousness. And it's from that there has been a conclusion, which is there's been no sustained positive neurological trajectory over many months. My lord will also know that if that's the case, one can classify a particular disorder as sort of effectively permanent, sadly. But look, that takes me to Professor T.S.
Dr. T, I think we're calling her.
Dr. T.
Well, it takes you to paragraph 7, first sentence.
Yes. Her letter is at 138.
So what? Yes, paragraph 7, first sentence. Dr. D is saying that Dr. T gave an expert opinion that RB's condition is TDOC.
Or RB's condition should be classified as that, I think, is the because it's they're both disorders of consciousness. It's how one classifies it, because one carries with it the.
What's the definition of TDOC?
It's in Professor
Dr.
TS's letter.
Well, is it anywhere else?
I think it will be in the disorders of consciousness guidance. I can get that for your lordship. It's not in the bundle. My lord will know that Dr. T, and she says so at 138, that she gives this is her clinical expertise. She is the national clinical lead for prolonged disorders of consciousness. That's the very last paragraph at 138. And the chair of the guideline development group for the national clinical guidelines for PDOC, which are the guidelines I've referred my lord to. She also has 35 years of experience of caring for patients with profound brain injury and disordered consciousness, and, as she says, increasingly involved in medico-legal cases with regard to ongoing care and treatment. My Lord Justice Baker was right to surmise earlier that her involvement was as a consequence of Dr. Prown's recommendation. I beg your pardon, Dr. P's recommendation. My Lord will remember that. That's at 134.
Recommendation of paragraph 4 in the last
The recommendation, and if one looks at that recommendation, it's very specific because it's about a suitably qualified neurologist who meets the criteria for an expert PDOC physician, and there are particular criteria in the PDOC guidance which say that this person is somebody who meets that criteria and therefore can opine on these particular issues. And Dr. T very clearly did and does meet those criteria.
But Mr. Plough, do we know number one whether she saw the patient?
She didn't, no. It was a paper review.
Do we know what documents she saw? Because it appears from this letter, one would have thought that one, as best practice, would put at the bottom the documents that you'd seen and mention that that's not there. And all she says at the beginning is, "Thank you for discussing this patient with me." So it's as if there's just been a discussion. But I just want to clarify what the position was.
My lady, I've tried to find out what the position is, anticipating that you may
Yeah.
ask that question. Can I come back to that? Because I don't have full instructions on it yet, because the relevant people weren't around at lunchtime.
Looks as though you might have instructions from behind.
I'm told that she had not only this conversation with Dr. S, which is clear from this letter, but there were others who were talking to her as well from the neurology and nephrology teams.
What was it, an online call or something?
Yes, I think that's exactly what it was.
But she did, in answer to the lady's question, what documents did she?
Yeah, so she was provided an email, a sort of email information as to the particular information, and that we will obtain and provide. It isn't clear whether she saw any medical records, and we don't think she did, but and I'm not sure whether she saw Dr. P's or Dr. P's report.
So she had conversations but no medical, no documents.
I think that's right, other than what was contained in the emails, which I will provide. My lord, it was on that basis that she then provided the letter. And she sets out at on the first page the sort of history of this patient, which is the unresponsive state in, this is the bullet points. So this is a patient who had a previous stroke, he's got diabetes, he presented in an unresponsive state, the MRI demonstrated multiple infarcts involving the brain bilaterally and the left pons, been successful weaning off the ventilator, but there's been no improvement in his level of responsiveness during the 7 months he's been with you. And then the treating team have described him as being in a minimally conscious state. He has intermittently required hemodialysis for chronic renal failure and is now dialysis dependent. And this was in November. And it's on that basis that she then comes to the terminology to describe his condition. And she says that it's, in her professional view, it's more accurate to call him in TDOC rather than PDOC, because this is a person who's had multiple strokes, as I understand it.
Well, he was found collapsed and never recovered consciousness. MRI revealed multiple infarcts. Well, why is that not a sudden onset acquired brain injury?
I don't
That's
know.
what happened to N and W and M.
Yeah.
He collapsed with that.
Again, without having any more information from Dr. T, I don't know. What I would say, though, my lord, is that I don't think it matters to the prognosis, because the prognosis was, whether it was PDOC or TDOC, very, very grave. There was
She says, two contexts, prolonged disorder of conscious PDOC, following a sudden onset acquired brain injury from which the patient may or may not regain consciousness, versus TDOC, towards the end of life progressive conditions.
but this was a chap who, at this point in November, so that's 7 months, had not regained consciousness. His trajectory had not indicated any level of recovery. So
suppose in the T-doc definition, there's reference to multiple strokes. There were multiple strokes.
there were. And there was a stroke history too. This wasn't his first time that this particular gentleman had suffered strokes. He'd had a history of strokes.
But Mr. Patel, what was the purpose of this opinion? Because you said that it was the other Dr. P and one of his recommendations, and then we get to this letter at page 138. I just want to know what your submission is about before we get to PDoc and TDoc. On page 138, the penultimate paragraph, where she says, "You've asked me for advice regarding the clinical decision-making process for withdrawal of treatment." So it seems as if she is advising the team at the hospital who wish to withdraw treatment. What is the process to do so, rather than necessarily considering the precise position of the patient? I'm not sure. I just want to get the balance in this letter of those two things, because I think she does go on inevitably to discuss the patient. But I just wanted your submission in relation to that.
My lady, I haven't got clear instructions about that, so I can't give you a clear answer to that. But what I can say is that from the letter itself, it appears it's both.
Okay.
And that's all I can add on that.
And that's what she does. She gives advice.
She does, certainly later on.
It's in the main, not a second opinion on the patient's medical condition. It's advice about how you go about withdrawing treatment.
Well, one of the difficulties about one of the things that occurred in this case, in terms of why this particular letter hadn't been disclosed earlier, is because Dr. T had asked for it not to be disclosed, and that might explain the purpose of it.
Was that asked?
Well, all of these second opinions were sought by the family, and in order to take instructions about it, my clients had to talk to the various authors of the letters. And one of the things that she said was that she didn't want that being disclosed because it was given, she said, in private.
So this wasn't a second opinion in line with the established procedure for seeking second opinions in these cases.
Well, part of it was, my lord, because it's a mixture. Because the second opinion that arose was in relation to the disorders of consciousness and her expertise in relation to that, and she did give her opinion about that, and that was primarily why she was instructed to do that. But she also gave this additional advice when it came to the clinical guidelines in relation to withdrawing treatment. That's evident from the letter.
Hence, without prejudice.
Well, I can't comment, my lord, about why it says that without prejudice. I'm a lawyer, my lord, and I don't know sometimes when to put without prejudice on something. So the idea that a non-lawyer is doing it is a little worry.
I'm sitting with two lawyers who definitely know. I don't remember seeing that at the top of a.
My lord, I can't comment.
What I was going to say, she's seen a lot.
Well, I think we've both seen quite a lot of them, and
Without prejudice.
No. I've seen a lot of reports, not
I've
with.
never seen without prejudice. Don't give evidence.
Probably not.
I think you're being offered further material.
So sorry, do you want to make a point in response?
No,
to
I was going to move on to.
Well, I was just wondering, how did it then come about that this was all disclosed? Given that she asked you not to disclose it, how did it come about that you did?
I think it was then going to be used in terms of relying upon it, and therefore it was disclosed.
Has there been full disclosure of all correspondence between the trust and Dr. T
No, the emails haven't been disclosed, as I've said. Haven't.
Thank you.
Well, going back to my lady, going back to the Dr. D's statement, because
Sorry, Dr. D's statement.
Dr. D's, please.
Yes.
Yes.
Presumably, by the way, also, just thinking it aloud, the clinicians on the Zoom call would have taken a note of, somebody on the Zoom call would have taken a note of what was said on the Zoom call between Dr. T and the clinicians of the Trust.
I'll take
Is
instructions.
that on the medical records?
I'll take instructions on that. I don't know.
Sorry, carry on.
No, no. So then we get to paragraph 8, and it's what the position is, and this is, I touched on this earlier, which is that this is not simply Dr. D's view, it's the view of all of the treating intensive care consultants, the neurology input, that Mr. B, oh, sorry, beg your pardon, has no prospect of regaining meaningful consciousness or achieving any recovery that would allow a return to independent life or a level of quality of life that he could experience. And then there's the issue about the kidney injury.
Is that a comment on his condition or his best interest?
My lord, I'd say that was a comment on his condition, because that's the condition he finds himself in at that stage, or they find himself in at that stage. He is somebody who has no real level of consciousness and is unlikely to regain it. But I think one of the difficulties is that obviously that can be seen as a best interest thing as well, because if one is then considering whether or not, if there is treatment to be offered, and you're weighing up the benefits and the burdens of the treatment in a best interest way, you would include this matter as well.
So it is part of the best interest, but if it comes under the definition of clinical condition, it doesn't count as best interest for the purposes of.
Well, it's not counting as best interest for the purposes of this decision, which is I'm saying there is space for this decision in this context. It doesn't have to be simply best interests and that's that. There can be a decision that the treatment is clinically inappropriate, and one of the factors that one takes into account is his current clinical condition. But on the other hand, if the decision had not been by all of the clinicians that it's clinically inappropriate, but they had reservations about its efficacy and the benefit compared to the harm, this would factor into a best interest decision. It's not mutually exclusive in my submission. And where it factors in this case is paragraph 12. A is about his condition. B is about the efficacy of dialysis for him in his condition. C is about the harms and safety of the treatment. And D is about what the overall purpose of, or the overall clinical aim would be of providing this treatment.
These are all clinical matters, you think?
These are. And that my lord and my lady, is where the decision was, or the basis upon which the decision was made. And as I said, this isn't a decision made simply by Dr. D, but it's a decision that has been discussed amongst the entire treating team. It's also, from a nephrology perspective, supported by the second opinion that has been obtained from Dr. E.
Just talking around it for a moment. Prolonging the process of dying does mean also extending life. So it is contemplated that dialysis would extend life.
Or it could extend life.
Could extend life.
Yes.
And then there's reference to continued dialysis being futile. It's not futile in the sense of extending life. So futile in what sense?
I agree with you. It's not futile in the sense of whether the treatment would be effective in terms of what dialysis is there for.
Yeah.
It's futile in the sense of his overall condition. Does it get him back to, or to give him a chance? This is an invasive treatment. Does it give him any prospect of getting back to where he could live his life? And my lords, my lady, we've got in my submission one of the reasons why this decision was taken at this time rather than earlier, because we had the evidence earlier, was because of the circumstances of the main catheter failing. And that's all set out in paragraph 14. So in terms of dialysis being a clinically appropriate treatment, that would also require, in Mr. B's case, the insertion of repeated temporary lines.
Just going off a tangent moment. So there's reference to avoidable harm, infection, bleeding, thrombosis, procedural complications. Probably approaching this from a position of ignorance. We don't get a discussion of pain here. We won't expect any discussion of pain or not.
My lord, I see that. I can't answer that question as to why it's not there or whether one would expect it to be there.
Pain part of condition or best interest or both?
I would have thought both. I wasn't going to say any more about the evidence that was before the Vice President. That was the evidence that I say we relied upon in order to persuade the Vice President this was a clinical decision.
The second opinion evidence, ignoring Dr. T's report, which I think you've more or less accepted, wasn't really a second opinion report in the conventional sense. Dr. D and Dr. E's reports were some months earlier than the actual decision, weren't they?
They were in October and November, yes.
And in November, yes.
Middle of November.
They were about 11 weeks
Yes.
also before the decision. Do you have any submission about that?
Other than nothing other than the fact that I think it was the failure of the line that crystallised the decision making for the team. If one looks at the timeline, because they were all having doubts about whether this was clinically appropriate in their judgment. Discussions about it, talking to other doctors about it, getting second opinions, but it was particularly about the tunnel catheter failing and therefore the increasing invasive procedure that then would be involved in providing or offering the dialysis. And of course, my lord, we had a further 11 weeks where this gentleman's neurological condition had not shown any sign of improvement.
Do you have evidence of that?
Yes, because there's been no trajectory in terms of where he's gone up and down. It's always been, isn't there been, it says in the evidence there's been no neurological improvement. And
I say that's Dr. D.
that's Dr. D, yes.
The evidence in these cases is now, you say, much unlike in the old days. You said when I was hearing these cases, the evidence is much on a much narrower compass.
It's on a much less specialised compass, if I can put it that way. There's no need for these structured, specialised assessments in order to make the diagnosis, or in fact to give a prognosis in relation to these matters. Those are clinical matters based upon observations. Well, unless there was anything else about the evidence, I was going to move on. We've touched on some of this already, so I'll try and take it as quickly as I can because I'm conscious that I won't leave Miss Watson much time. But the essence of the legal structure, I say, which says there is room for both clinical decision making as well as best interest decision making, comes in my submission from the Court of Appeal's decision in Burke, the GMC guidance, which reflects the case law, and from a proper understanding of what the Court of Protection is doing when one is looking at what decisions they're making and the basis of their decision, the court's decisions on behalf of someone who lacks capacity. And that submission is based on the fact that the Court of Protection, which is a creature of statute, has no greater powers to exercise on behalf of a person lacking capacity than a person with full capacity.
It has no great, how exactly do you put that? No greater powers. What?
It doesn't have any greater decision-making powers in relation to any decision, whether it's a treatment decision, whether it's a care decision, whether it's a finance decision, than a person who has capacity to make those decisions.
It's a different process altogether.
Well,
When a person makes a decision on their own behalf, it's by definition a subjective decision. When you're making an assessment of someone's best interests, it's by definition an objective decision, having regard to their wishes and feelings. It's not a substitute decision, as we know. A fundamentally different process.
well, it's a different process, but it doesn't mean it's a
How does it help to say it's no greater?
well, because a person, what the Court of Protection is there to do for a person who lacks capacity is take decisions that they would have taken had they had capacity, or would have been able to take.
I'm very conscious that it's probably better to let you make the submission, but can I just put this to you? Doesn't the way the Act is very clearly drafted impose on everybody making decisions in respect of incapacity evidence a completely different structure to how decisions are made about capacities people? You have to make a decision. Any acting decision has to be made in the best interests of any act, including by health professionals. That's what the code says. Confirming what the statute says simply in section 1, subsection 5. So,
Well, that can't literally mean any act or any decision, because we know, take the case of N that went to the Supreme Court, where the ICB decided they weren't willing to fund a particular set of carers in order for P to have contact with his mother, I think it was. The Court of Protection wasn't able to say, well, that's in his best interests, because that was a question about whether, in fact, it should be funded. Yes. So we know, therefore, that in that regard, P cannot insist on more favourable outcome than a person with capacity. And that must be the case in relation to other aspects of decisions which are to be made on P's behalf, such as treatment decisions. If a capacitous individual can't demand a particular treatment and say, although you're not offering me this treatment, I consent to it, and therefore you must give it to me. Capacitous person can't do that, and it's very clear from the authorities that that's the case. It can't be right that a person who lacks capacity can say, well, it's in my best interests, and therefore I ought to have it provided to me, even though you're not offering it to me.
That isn't how it works, is it?
It is how it works, because
no one's proposing that people should be entitled to demand for the incapacitous adult that they receive treatment irrespective of funding or commercial or clinical judgment. They're saying that the decision has to be taken in the best interests, and if it can't be done by agreement, in serious medical cases, it has to go to court.
But my lord, if the clinical judgment is that the treatment is not available to the person who lacks capacity for reasons outside of their capacity, it's just clinically not available, then that would be the question. If they were to say, well, it's in my best interest, you must provide it, that would be that person demanding that treatment. Or it would be demanded on behalf of them under the guise of best interests. And if the person with capacity cannot do that because you can't force a doctor to provide treatment that he or she determines is clinically inappropriate, then you can't get to that position simply because the Court of Protection is making decisions on behalf of P because P lacks capacity. And that, in my submission, gives the space for the clinically appropriate decision making as well as the best interest decision making. And one doesn't then, and if that's right for treatment in general, which I say is right, there is no, in my submission, scope for a different regime to apply in relation to life-sustaining treatment, because one can equally make that clinically inappropriate judgment in relation to that treatment. It might be more complex, it might be more difficult, it might be more grave, but it's still a professional judgment that would be made.
If this submission was right, one might expect the code of practice and all the guidance to say so clearly that in cases of life-sustaining treatment, the first question is the treatment, post-treatment, clinically appropriate? If the doctors say it is not, that is the end of the matter. If the doctors say it may be, and there are issues, then they will be resolved by the family and, if necessary, by the court. But none of the guidance, none of the code of practice says that at all.
Well, my lord,
It's the opposite.
the code of practice for the under the Mental Capacity Act, it concerns the Mental Capacity Act in best interests. It doesn't concern this particular prior question and decision. Because specifically, if one looks at 5.29, which is the specific section in relation to life, I think it's probably best if we do that.
Well, we start with the beginning, first paragraph of section 5.
So can you tell me where we're going?
It's page 88 of the authorities bundle. My lord, the premise, or the title is, what does the Act mean when it talks about best interests? So we're already into the scenario of best interests. And then it's one of the key principles of the Act is any act done or a decision made on behalf of a person who lacks capacity must be done or made in the person's best interests.
Well, that's rereading section 1, subsection 5. one
Well,
might
yes.
expect at this early point there to be, if the exception you're postulating apply, for that to be spelled out here, if not in the Act itself. In fact,
Well,
it should be in the Act.
But my lord, if one says, and if one is right that funding decisions which impact upon best interests available options is something that means that that bold statement doesn't apply to people who lack capacity, because you can't have everything you want because of funding decisions, then one would expect that to be in the code of practice, but it isn't. And therefore the code of practice is there determining what the proper sphere of best interests is. And that's
So how to be precise then, how should we read the first sentence of that?
well in the
to be precise, rather than the loose language which the Act uses.
well in the way that the Supreme Court in N tells us to, which is that any act of done or decision made of available options on behalf of a person who lacks capacity must be done or made in that person's best interests. That would be strictly following the Supreme Court's judgment in N, how one would read it.
Any decision about available options.
Options that, in relation to the decision or act made available to that person must be made in that person's best interests, and that would be the case, and that follows from the Supreme Court's judgment in it.
You're going to take us to, you want to share that?
Yes.
But before you do that, also we were at page 88, page 91. Also in the code is the heading exceptions to the best interest principle at 5.4, and it has two exceptions which aren't relevant here. It doesn't make any other express reference to exceptions.
But I think that's in relation to things that can occur under the Act.
Yeah, and you would say
This is not
prior.
Indeed. My lady, my lords, N is at tab 24. And the relevant passage is at paragraph 35, which is at 869. So how is the court's duty to decide what is in the best interests of P to be reconciled with the fact that the court only has power to take a decision that P himself could have taken? It has no greater power to oblige others to do what is best than P would have himself. This must mean that just like P, the court can only choose between the available options. In this respect, the Court of Protection powers do resemble the family court's powers in relation to children. The family court must also decide what is in the best interests of the child, although in Children Act 1989 this concept is not expressed but implicit in the court's duty to regard the welfare of the child as its paramount consideration. But the court cannot oblige an unwilling parent to have the child to live with him or even have contact with him any more than it can oblige an unwilling health service to provide a particular treatment for the child. This was explained in Holmes, Morehouse and Richmond upon Thames, London Borough Council. When any family court decides with whom the children of separated parents are to live, the welfare of those children must be its paramount consideration. This means that it must choose from the available option the future which will be best for the children, not the future which will be best for the adults. It also means that the court may be creative in devising options which the parents have not put forward. It does not mean that the court can create options where none exist. The Holmes-Morehouse case is important for another reason. It demonstrates how the family court is operating on a different plane and on different principles from a public authority which is deciding how to exercise its statutory powers and duties to provide services the parents of 3 children had separated, the mother remaining in the matrimonial home and the father being ordered to leave. The family court made a shared residence order by consent. The children should live with each parent. The father then applied to the local authority to be housed under its duties to the homelessness. These duties vary depending upon other things, upon whether an applicant is in priority need. The priority need include a person with whom dependent children reside or might reasonably be expected to reside. The father argued it was reasonable to expect the children to live with him, as the family court had ordered that they should. The local authority decided it was not. The Court of Appeal held that the shared order meant it was not. The House of Lords disagreed. Lord Hoffman explained at paragraph 14 that the questions for the family court and for the local authority were not the same. The question which the housing authority therefore had to ask itself was whether it was reasonably to be expected in the context of a scheme for housing the homeless that children who already had a home with their mother should be able also to reside with their father. In answering this question, it would no doubt have to take into account the wishes of both parent and the children themselves. It would also have to have regard to the opinion of a court in family proceedings that shared residence would be in the interests of the children, but it would nevertheless be entitled to decide that it was not reasonable to expect children who were not in any sense homeless to be able to live with both mother and father in separate accommodation. The authority was entitled to take into account the fact that housing was a scarce resource, the claim of the other applicants and scale of its responsibility when deciding the issue of reasonable for this purposes, nor should a family court use its powers as a way of putting pressure upon the local authority to decide in a particular way.
Do you want to read, I mean, you don't have to read it, but you no doubt rely on paragraph 37 as well.
My lord, yes.
So is in essence your point is that the restriction on to available options in terms of resources applies equally to so-called clinical decisions.
I wouldn't necessarily frame it as resources in that respect, but it's a prior decision in my submission that informs the best interest options. Because best interest in this context, my lord, in my submission is the substituted consent for the treatment that's offered. It's the option to a capacitous individual is, do you consent to this particular treatment I've offered you? Yes or no. If I don't offer it to you, you can't demand it, no matter how much you want to consent to it. And it's the same for a person who lacks capacity, because best interest is there, effectively substituting capacitous consent for best interests. And so when the code of practice talks about best interests and doesn't talk about clinical decisions, it's because it's talking about best interests in terms of available options under the Act. Talking about what this person, the person who lacks capacity, is able to require by way of best interests in terms of what act can be done or decision can be made on their behalf.
And that means that a decision, a decision about at a point where the hospital were still willing to offer dialysis to RB, would that be a decision which would be capable of resolution by the court?
If the hospital...
And so with the result that it only became taken outside the court's sphere once they decided for clinical reasons.
Well, it's taken out outside the court of protection sphere.
Yes, well,
it's not taken outside the court sphere because
it's taken outside the court of protection.
Yes,
taken outside the whole best interests architecture, the
yes.
whole architecture of the Act.
Taken out of that sphere because the professional judgment of the doctors is that this treatment is no longer clinically appropriate, and therefore we're not offering it.
And just to be clear, though, I think we are being clear about this. you say there's a divide between clinical, where the Court of Protection can't get involved, and best interests. And I think you say where the line is drawn is a matter for the doctors and the hospital, because the Court of Protection can only choose between options that are made available by the trust.
Yes, but that's not a line that that's free from scrutiny from the courts, because that's a line, or the lawfulness of where that line is drawn can be determined in judicial review proceedings.
That obviously would be a very different thing, because in the Court of Protection context, you just ask what are the best interests. In judicial review proceedings, it's a matter of rationality or taking into account wrong considerations.
Well, my lord, it's not as wide a line as one might think, because if one is dealing with life-sustaining treatment, as we are in this case, we have human rights considerations, and in those circumstances, the case of the JB and Haddock says that there's a full merits review by the court. It's not simply rationality that one's talking about. One would obviously pay a great deal of respect to the doctors and the doctors' decision making, but it's a matter for the court to determine the matter in judicial review proceedings by way of full merit. I think probably where the line is to be drawn is that in a best interests analysis, one would probably have other evidence which might inform the best interests of the patient. Whereas if one is looking at a review, albeit a full merits review, one is really looking at what the doctors and the context of the evidence that there was, and there would probably be very little scope for including expert evidence in that regard, even though it was a full merits review. Well, can I? When my Lord Justice Baker said that the guidance didn't provide for this and didn't deal with this matter, that's correct in the Mental Capacity Code of Practice, my Lord, but not correct in the GMC guidance. The GMC guidance, which obviously informs the doctor's analysis, informs their decision making, very much makes a distinction between clinical decision making leading to a determination of what treatment, if any, is clinically appropriate. This is at page 332 of the authorities bundle. Paragraph 14. So in relation to patients who have capacity to decide, it's 14. If one turns over 2 pages, in relation to patients who have who lack capacity, that's paragraph 16. But if one looks at the steps, the steps in the model, steps A and B.
Are we in paragraph 14?
14. Steps A and B in 14 and steps A and B in 16 are identical effectively, and the stage is assess the patient's condition, clinical condition, and then use your specialist knowledge, experience and judgment and form a view about whether treatment, if any, or any particular treatment is clinically appropriate. And then it's thereafter that the model is depending upon whether one is dealing with a capacitous patient or when one is dealing with a patient who lacks capacity. A person who has capacity, you'll see that C, the patient himself or herself weighs up the potential benefits, burdens, risks, etc., as well as any non-clinical issues that are relevant to them. The patient decides between the options. They also have the right to accept or refuse an option for a reason that may seem irrational or for no reason at all. And that's giving effect to the patient's right of self-determination, the patient's autonomy, a capacitous patient's autonomy. And then D, over the page to 333, if the patient asks for treatment or care that you don't think would be clinically appropriate, you should explore their reasons for requesting it, their understanding of what it involved, and their expectations about the likely outcome. This discussion will help you take account of factors that are significant to the patient and assess whether providing the treatment or care could serve the patient's need. If after discussion you still consider that the treatment or care would not serve the patient's needs, then you should not provide it, but you should explain your reasons to the patient and explore other options that might be available, including their right to seek a second opinion. And then 16 is the person who lacks capacity. So A and B, as I said, is the same. C is about they may have made an advance refusal of treatment, which under the Act you would then have to respect, so you would need to deal with that. They might have a attorney or other legal proxy appointed, and you'd have to deal with that because that would be the person who would make the best interest decision. And then F, in circumstances in which there is no legal proxy with authority to make a particular decision and you are responsible for making the decision, you must consult with members of the healthcare team and those close to the patient before reaching a decision. When consulting, you will explain the issues, seek the information about the patient's circumstances, and seek the views about the patient's wishes, preferences, feelings, beliefs, and values. You may also...
Are we here still talking about the clinical condition?
No, this is best interest.
This is now best interest.
You may also explore which options those consulted might see as providing overall benefit for the patient. The phrase, my lords, overall benefit is used because
It's a Scottish phrase.
Indeed, it's as well as England and Wales. So
Yes.
it's effectively best interest.
Yes.
And it says you must take the views of those consulted into account in considering which option would be least restrictive to the patient's future choices, and in making the final decision about which patient is of overall benefit to the patient. And then in G, it talks about appointing an IMCA in England and Wales. And then it says, H, if disagreement arises about what would be of overall benefit, so in other words, what would be in the person's best interest, you must attempt to resolve the issues following the approach in 47 and 48. And in I, it says at the bottom, you should explain your reasons to the proxy or other person involved in decision making, explore other options that might be available, including their right to seek a second opinion, applying to the appropriate statutory body for review, and applying to the appropriate court for an independent ruling. And then 47 and 48 are about resolving disagreements.
Sorry, before you go on,
Yes.
you were saying that 14A and B are much the same as 16A and B, capacity, lack of capacity.
Yes.
But in B, in relation to 16,
Yes.
where there is no capacity, one is looking at the end there, what is in the patient's clinical interest, and decide which of those options is likely to result in their overall benefit. So overall benefit, which is a catch-all phrase, including Scottish terminology,
Yes.
comes up right at the top when one has no capacity, it would seem, within those first sub-paragraphs that you were saying are the same, whether
Yeah.
they have capacity or not. And I just pointing out that I'm not sure that's so. What is the relevance of overall benefit in B, 16B?
My lady's quite right. There's different terminology used in B.
But is there?
Well-
Does that have an actual effect, or is it much the same?
My submission would be it's much the same because one is dealing the same. You're doing the same stage for both the person with capacity and one without capacity.
Yes.
So you're deciding in terms of at that point from a clinical perspective what is appropriate or not.
So what's the reference? How should I take the reference to overall benefit in 16B?
Well, I mean, I think my submission would be that bit shouldn't be there
Oh, okay.
because
what about
it's,
paragraph? Sorry, I'm sorry. Interrupt the
No, no.
lady's question. Following on from that, paragraph 30.
1-3.
Yeah, go back just above. If your others conclude that an adult patient lacks capacity, Decisions you or others make on the patient's behalf must be based on whether treatment would be of overall benefit to the patient.
Yes, I think that's why I say that shouldn't be there in 16B, because
It's a mistake, is it?
overall benefit is about best interest.
Yes. Well, is,
Yeah,
doesn't that doesn't? Well,
but that would.
so that shouldn't be there.
I don't think it. I don't think it's appropriate to be
But
there.
it is there.
I appreciate that.
This is the guidance that the GMC doctors are following up and down the country and trying to.
But it doesn't make sense in the context of the rest of paragraph B, because the rest of paragraph B is about
Paragraph B of
16. Because the rest of paragraph B about 16 is about clinical interests. And it's about clinical, using your clinical judgment. It's exactly the same wording as 14B.
well, what's the time? You
And then it talks
start
about,
off by making an assessment of the patient's condition.
yes,
A. That feels like a focusing on the medical situation, the clinical picture. You use your special knowledge to decide what's in the patient's clinical interests and decide which of those options is likely to result in their overall benefit. So there's two things going on here. First of all, a clinical evaluation, and secondly, what we could probably call a best interest evaluation.
yes,
Both of which are in play here, because under 13, the question is
well, but
that the decision must, my emphasis, be based on whether the treatment would be of overall benefit to the patient.
But as I understand it, on your case, 16B has two stages really. Stage 1, you identify the options, which you say informs the re-end type exercise.
yes,
And then the doctor is told to decide in his own mind or her own mind which is likely to result in the overall benefit, which would feed in on this thesis to say little d, where the doctor can recommend a particular option and then the legal proxy makes the decision.
yes,
So in your thesis, whether or not it's right, you, so to speak, got preparation for the second stage in B, where the legal proxy or someone else is going to decide on overall benefit.
because, sorry, your lordship's quite right, and I rushed into a conclusion earlier. That is a two-stage process in B. The second stage is so that then, if in fact the doctor is the decision maker, because the doctor might be the decision maker if there's no legal substitute legal proxy.
And that's little f.
That's little f.
Yeah.
Then that will inform the doctor in terms of best interests. If the doctor isn't the decision maker because there is an attorney or there's some other legal proxy, then it will also inform what information they say to that person so that they can then make that decision. And that's a decision about best interests. But one is still, one is then talking about best interests at that stage. It doesn't obviate the first stage, which is the same as a person with capacity.
This guidance is now some 16 years old, isn't it? Not as old as the, am I right? Unless there's a new one.
No, it was updated in 2024, I think.
Oh, I see.
I think it.
What changes? Will this section materially change?
I don't know. My lord, I could do that research if you'd like me to.
Well, it'd be quite interesting to know because it might be relevant to decide whether there's any, to decide strength of your argument about the analogy with Rian.
I can certainly do that. I can try and do that exercise.
But if well, I think we've covered it. So on the argument against you will be that paragraph 13 is the decisive paragraph.
13.
1-3, the one we've just looked at. You say it's a mistake.
No, sorry, my lord. I don't think 13.
If you're executed in lax capacity, the decision must be made on whether treatment will be of overall benefit to the patient.
Yes, but that's a statement that has to be seen in the context of 16A and B, because 16B has two stages, which is this, deciding whether investigations, treatment or options for managing the patient's condition, including the option to take no action, are in the patient's clinical interests. So I
Which would be the word available.
I would say that you could make at that stage a decision that there are no treatments that are available.
In terms of dating, which you may come back to, I see there's a legal annex endnotes at 367 to 368, which I don't think includes N, but it does include a 2018 Supreme Court case. So it must have been updated at least to 2018.
It includes, that's why, isn't it? Yes.
Why, yes. My lord, it says on the face of the document at the beginning at 324, that the guidance
Yeah,
was
I see,
last
yes.
updated on the 13th of December 2024.
Yeah. Now we
This is
need to keep
24.
an eye on the clock, because there's obviously Miss Watson and also Mr. Quintervale in reply.
My lords, yes.
You've very helpfully been engaging with the questions. What else do we need to cover?
My lord, I think that I think I don't need to make any more submissions about the sphere between clinical decision and best interests, and that grounds 3 and 4 fall or on that basis. In relation to ground 2, which is the ground about whether, in fact, leave was required, I think even if there is a procedural irregularity that the learned judge didn't appoint or sought to join P, but P was not in fact joined because there was no litigation friend appointed, it doesn't then follow that that means that it had a error not occurred, that the inevitable consequence of that is that no leave would have been required for under section 50.
Well, she would then have applied as litigation friend.
She would then have she would have
need permission.
but the learned judge would have then had she not proceeded on the basis that she didn't need to appoint a litigation friend for P, which was erroneous under the rules unless you say that his interest was secured under 17.3E, I think it was 2E.
Yeah.
She would have had to appoint a litigation friend, and it doesn't follow that litigation friend would have been the applicant. In any event, this wasn't an argument that was advanced before Mrs. Justice Tice. Everyone was aware that that P didn't have a litigation friend in the hearing below, and it wasn't said to her, well, you know, if Miss LT becomes litigation friend, then we can just be redundant about whether in fact leave should be required under section 50. So that's ground 2. Ground 1 is does Article 2 or the common law require the possibility of going to court when there's a dispute? Well, positive obligation under Article 2 requires that. It doesn't require the court of protection. That's not it. What is specified are matters of national law and the margin of appreciation under Article 2. So the fact that the court of protection isn't available in our submission to deal with complaint or to deal with disputes about clinical decisions doesn't render the whole process Article 2 non-compliant. And the common law requirement that comes from the Supreme Court's decision in Y, in my submission, it is that was a case about best interest. It was about whether it was in a particular person's best interests to be provided with life-sustaining treatment in the form of clinically assisted nutrition and hydration, and what the requirements of coming to court were in those circumstances. It doesn't impact upon any disputes about clinical decision making, which is what we have here. Well, the last point I'd make is the case that I gave your lordships right at the very beginning.
Did you want to say anything about GUP, which I asked you to?
You did. I align myself with Miss Watson in relation to
Yeah,
GUP, and so I think I might leave it to her to, without ducking
You
it.
don't want to mention the guidance, the former Vice President's
So the
guidance.
form of, I say that's the same as the Mental Capacity Act code, which
So
is it
it-
deals with best
Vice
interests.
President's interest.
My lord,
And that GUP suggests that isn't what he thinks. So we let Ms Watson deal with that.
I think so.
Yes.
Sorry. Well, the last point I make then is this case of Medellin in France, and this was a case, you will see it at paragraph 1 on page, I think it's 4 at the bottom. The application concerns the medical decision to withdraw life-sustaining treatment from the brother of the first two applicants and the husband of the third applicant, despite his having drawn up advance directives stating that he wished to continue to be kept alive, even artificially, should he lose consciousness permanently and to be unable to communicate with his family. And it was brought as a complaint under Article 2. And in due course, this particular gentleman suffered an accident. He was in an accident. He went into a coma. He lost consciousness. He lost it permanently. And the issue in the court was whether, in fact, the advance directive, he could rely upon the advance directive in order to insist on treatment, by which time he was lacking capacity. And the court said at 48, well, first of all, I think it might be best if I took you to 39, which were the court's recital of the factors in determining whether the positive obligations have been complied with, which are the ones from Lambert, which my learned friend took you to. And then paragraph 40, the court saying that the states have a margin of appreciation not only as to whether or not to permit withdrawal of life-sustaining treatment and the modalities of its implementation, but also how to strike the balance between the protection of a patient's right to life and the right to respect for private life and personal autonomy. And then over the page to, over 2 pages to 48. Furthermore, the court reiterates that when it comes to the withdrawal of life-sustaining treatments, reference must be made in the context of examining a possible violation of Article 2 to Article 8 of the Convention. It was held that while Article 8 guarantees the right to personal autonomy as an element of the right to respect for private life, it does not oblige member states to give binding legal effect to advance directives. And then furthermore, the Council of Europe Guide on Decision-Making Process relating to medical treatment in end-of-life situations, which should be taken into account, indicates that autonomy does not imply a right for the patient to receive any treatment that he or she may request, in particular when the treatment in question is deemed inappropriate, since the decision regarding healthcare results from the meeting of the patient's wishes and the assessment of the situation by a professional, subject to his or her professional obligations, and in particular those arising from the principles of beneficence and non-maleficence, as well as justice. So in my submission, that is a expression of the court where the court says that Article 2, what Article 2 requires by way of life-sustaining treatment to a person who lacks capacity.
Thank you very much.
Thank you very much.
Ms. Watson.
My lords, my lady, may I begin with ground 2, which I hope to be able to take relatively shortly in light of the submissions that you have already heard from Mr. Patel. It is respectfully submitted that whether or not that ground is reframed as it seemed to have been today, or remains as set out, it is a misconceived ground of appeal. It is very clear in this case from the application that was filed with the court, that you will find in the core bundle at page 43, that the applicant was LT. The applicant was not Mr. RB. Mr. RB was named as a respondent, and we can see that in the supplementary bundle, page 3, and the official solicitor in the application was listed as a person to be served with the application as prospective litigation friend. It's right to note that the certificate of suitability filed by LT after the application had been listed proposed that she act as litigation friend, but it is also right to note that application, as it were, was not in fact determined in her favour, and as the court is now well aware, and you can see from the order in the supplementary bundle, page 14, no litigation friend was appointed, and in fact, Mr. RB was not joined as a party to the proceedings.
I didn't understand that the issue was investigated at all, is that right?
The issue was investigated by Mrs. Justice Tice prior to the hearing being listed, in the sense that inquiries were made with the official solicitor regarding her position in respect of the order that had been made that she be appointed as litigation friend subject to her consent. It may help to have a little context for this sort of application. It is rare, indeed I have not in over 25 years attended a hearing in the Court of Protection at which permission has been considered. It is usually granted on the papers following a COP1 application form being submitted. The experience of those in the official solicitor's office is on all fours.
Application for permission on section 50.
Yes, an oral hearing is very rarely, if ever, listed to consider permission. And
Is there any reported case on it?
there are two, my
No,
lord.
tell me I was one of them.
No, my lord, you will see that we've included both of those in the bundle. They relate not to medical treatment decisions, but to decisions essentially regarding contact. The first of those, if it is of assistance, I apologise, is NK and VW at tab 20, page 759. I say, my lord, my lady,
Let Ms. Justice McClure.
yes. I say there are two. There are two that those of us instructed in this case have been able to identify. I'm not aware that there are any others, but I'm sure that if there are, I will be told. And both of these decisions considered the appropriate test under section 50, subsection 3. The decision of Mrs. Justice McCurry, she then was in NK, concerned an application by a family member to bring proceedings in the Court of Protection in order to be appointed as a deputy and to determine a move from one place of residence to another. The second decision is A and B, more recently in 2020, a decision of Mr. Justice Mostyn, as he then was, an application again by a family member for permission to bring proceedings in the Court of Protection to determine issues of contact.
Which tab is that?
That is tab 27, my lord.
Does the official solicitor endorse that judge-made test for?
My lord, I haven't taken express
arguable
instructions on that, but yes, a good arguable case or reasonable real prospects of success. Because if the permission filter is to have any meaning, then there must be a good way of preventing cases with no real prospect of success from taking up valuable court time. And so that must be an appropriate test alongside that which was set out by Mrs. Justice McKerr in paragraph 16.
Well, don't you start with the statutory criteria?
Indeed, if it helps to take it chronologically, in the case of NK, that's tab 20. At page 760, Mrs. Justice McKerr set out the statutory criteria under section 50. Which, my lords, my lady, you also have elsewhere in the bundle. But the four factors set out in the Act are that the applicants must have a connection with the person to whom the application relates. The court must consider the reasons for the application, the benefit to the person to whom the application relates, or the proposed order or directions, and whether the benefit can be achieved in any other way. Those are the four criteria. And in my submission, the gloss, if you like, put on it by Mr. Justice Mossin, Mrs. Justice McKerr, relates to subparagraph C, the benefit to the person. Because, of course, if an application has no real prospect of success, there is no arguable case to put, then it cannot properly be said in my submission that there is any benefit to the person to whom the application relates.
I don't think Mrs. Justice McKerr added the gloss. I think she just applied the statutory test of 53C, didn't she? Decided, treated on the facts it wasn't to the benefit of P.
My lord, yes, but with some explanation at paragraph 16 on page 763. Because in concluding that there would be no benefit to P in granting permission in that case, she said this: in doing so, I obviously consider that section 50 subsection 3 and the associated rules require the court to prevent not only the frivolous and abusive applications, but those which have no realistic prospect of success or bear any sense of proportional response to the problem that is envisaged by NK in this case. So whether one puts it as no realistic prospect of success or an arguable case in my submission, it comes back to a proper application of the criteria in section 50 subsection 3 regarding benefit to P. In the majority, the vast majority, I may say, of cases, these applications are dealt with on the papers with no need for an oral hearing. And the usual course of action is that the official solicitor in cases concerning serious medical treatment will be invited to act as P's litigation friend subject to her consent.
There's no case, and the OS would know this, there's no case in which permission has been refused to an application in respect of serious medical treatment.
Not to our knowledge.
Because most such applications, is this right, are brought by the trusts?
They are. And they are brought by trusts in circumstances where there is a best interests issue in the sense of best interests as we understand it in the Court of Protection, which is justiciable. So the official solicitor will always accept the court's invitation to act as litigation friend in serious medical treatment cases which concern an evaluation or assessment of P's best interests.
This is the first occasion in the 19 years since the Act's been brought, 18 years since that's been brought into force, that you're aware of, the OS is aware of an application being opposed on the grounds that the case does not come within the category of best interest decision.
That's right. That's right. Other cases have been dealt with, as we understand it, in what has become a conventional way. That is to say, permission has been given on the papers, and the parties have proceeded to court, and any arguments about available options arise once the court is seized of the matter. And that is what, my lords, my lady, you have seen in a number of the authorities to which you have been taken. The issue of availability.
We haven't professors' authorities in detail. We haven't looked at GUP yet.
No, and I
Which went the other way. Of course, GUP isn't really on. This is Justice Henke.
took a different view. Yes. And arguably, Mr. Justice McKendrick would have taken a different view,
One sentence.
subject to the evidence that was presented to him. But to set the scene, as it were, this is the sort of application which would be dealt with on the papers. Case management would be dealt with on the papers, so that there would be appointment of a litigation friend, and if considered appropriate, P would be joined as a party, which P invariably is.
This isn't so out of the way extraordinary an application, is it? To put this in a new category, this feels like a change of approach by professionals to this situation.
My lord, to a degree, yes, it is, and that has got to be acknowledged on behalf of the official solicitor. It is a change of approach, because in a number of these sorts of cases, we will have an application being made by a trust on the basis that they do not consider it ethical to continue to provide treatment, whether that be to an incapacitated adult or, in the context of children, to a child. But if ordered to do so, they say they will be willing to comply with the court's order. The unusual feature of this case is that the trust have steadfastly maintained the position that they would find it unconscionable to provide the treatment that is under consideration in this case, and will not do it. So it is distinct from a number of the other cases in which the clinicians will say, we don't think it should be done, but we would be willing to do it if the court considered it to be in the person's best interests. And had that been...
Fair to say there's a degree of professional disagreement about this.
Professional disagreement, my lord, in respect of whether or not there truly is a clinical decision without best interest.
Yes, following the GUP and Mr. Hayden and Mrs. Justice Henke's cases.
My lord, certainly at the bar there is. Yes.
In the notes to this passage in the Blue Book, which for the record, not a passage I edited, it refers to two blogs.
Indeed.
Giving opposite views, one from Miss Roper, one from Miss Butler Cole, I think, two distinguished circuits.
That is right. Yes, yes.
So this is a change of professional approach that's now being proposed. And what's striking is that the OS, through you, is taking a position on this, as opposed to doing what one might have thought the advocate of the court would do. I'm not criticising. We might have thought the advocate would say, well, here are the 2 points of view.
My
You're
lord,
not saying that. You're saying this is right.
may I preface my submissions with an explanation of the position taken by the official solicitor, and that is this. If the Court of Protection is to be invited into the arena of clinical decision making, then one would expect a far greater number of cases to come before the courts, and that would become, in the official solicitor's view, unmanageable, because it is the official solicitor's view that each day clinicians are required to make numerous clinical decisions with which their patients may not always agree.
It's been like that since the MCA came in.
Indeed, and an example which I have tried to provide the court through the case of Tracy is decisions in relation to cardiopulmonary resuscitation. That, of course, is a potentially life-saving treatment or life-sustaining treatment, but it has long been accepted that a clinical decision made not to provide CPR and a decision made to put on a patient's notes a DNA CPR order, as they've come to be called, is not a decision that is amenable to scrutiny by the Court of Protection on the basis that it is one which has inherent within it a consideration of best interests. And the reason I have highlighted that is because it demonstrates in my submission that there must be a legally significant distinction between clinical decisions and best interests decisions. And the key issue must be the use of the term best interests, because it does appear to the official solicitor that that can be loosely used. It can be used colloquially, but when we get into consideration of the jurisdiction of the Court of Protection, we know that best interests has a very specific meaning. And we know that because the Supreme Court in Aintree and James was asked to clarify precisely what best interests should encompass, and the court did so in what is now a well-known passage at paragraph 39 of that judgment. It may help to have a look at that. That is at page, it's tab 21,
always
page
get what we want.
781.
Is that the way she says we can't always get what we want?
My lord, no, it was the exposition of best interests, which goes beyond medical best interests. And the need for that exposition was because there is a distinction, we will say, between purely clinical decision making and best interest decision making.
I'm sorry, which paragraph?
It's paragraph 39, page 781.
This is about a withdrawal of treatment case.
It is. What was needed at that stage in the developing jurisprudence was a clear exposition of what should be taken into account when applying Section 4 of the Mental Capacity Act and considering a patient's best interests. And as can be seen in paragraph 39, Baroness Hale had said the most that can be said, therefore, is that in considering the best interests of this particular patient at this particular time, decision makers must look at his welfare in the widest sense, not just medical, but social and psychological. They must consider the nature of the medical treatment in question, what it involves and its prospects of success. They must consider what the outcome of that treatment for the patient is likely to be. They must try and put themselves in the place of the individual patient and ask what his attitude to the treatment is or would be likely to be, and they must consult others who are looking after him or interested in his welfare, in particular for their view of what his attitude would be.
And this is all decision makers, is it? These are decision makers,
My lord,
without qualification.
it must be all
Doctors,
decision makers, social
doctors.
workers, local authority decision makers, yes. But in the context of healthcare decisions, it is the official solicitor's position, and we align ourselves with the trust in this regard, that there are two distinct stages, or in fact, as I set out in paragraph 29 of my skeleton, three distinct stages. Those three distinct stages, my lords, my lady, you will no doubt recognise, mirror those that were set out by my learned friend Mr. Patel. We submit that firstly the clinician makes a medical decision that is based on medical matters only about the available treatment options available to a patient, and that is on the basis of an assessment, a medical assessment, which can only be performed by appropriate experience and expertise, which the Court of Protection doesn't have, an assessment of the patient's condition and prognosis. And that is stage one. It's at stage two, when discussing the medically available treatment options with the patient, that the clinician must then consider whether or not the patient has capacity to make their own decision. And then the third stage, if the person lacks capacity, is when best interests in the wide sense described by Baroness Hale in Aintree and James comes into play. And it is only at stages 2 and 3 that the Court of Protection will have jurisdiction. It may be unhelpful, but I was going to propose Another example.
Can I just go to paragraph 45?
Of course.
Which is another passage quoted from Entry and James. That's where Lady Hale says we can't always have what we want.
Yes.
Channeling the Rolling Stones. And that's the context in which, for example, which applies to capacitors and to incapacitors adults, whatever you may want for, whatever the family may want for, may not be possible for a variety of other reasons.
Yes, and you can't
That's
always
the
get.
best interest. That's the best interest analysis.
Well, my lord, you can't always get what you want is effectively repeating the now very well established principle that a patient cannot demand from a medical doctor treatment which that doctor is not willing to provide in my submission. And that is to say that if a doctor has made a clinical judgment, it is not for the capacitous patient to be able to go behind that, nor is it for the Court of Protection to be able to go behind that.
In making the clinical judgment, and in an incapacitated adult, doesn't the doctor have to take into account all the circumstances, all the best interest circumstances? The
At
judgment
stage 3, yes,
Well,
my
there
lord.
we are.
And
That's
The example I was going to give was one that was hopefully rooted in perhaps a little more medical realism than the COVID bleach analogy. But if for example a patient presents with a spinal cyst, a syrinx, and that patient's syrinx is expanding as they do and causing a compression of the nerves of the spine. It is theoretically possible the clinician may conclude, based on their knowledge and experience of dealing with this condition, to operate and to drain that cyst. But the clinician may come to the view, based purely on clinical judgment, that they're not willing to do that because the risks are too high. They may kill the patient, they may paralyse the patient. But the patient capacitus, having checked what options might be available from a review of the internet, says, well, I appreciate you say there's a 90% morbidity or mortality rate with this surgery, but I might be in the 10% and I want you to perform this operation. The doctor is not required to simply acquiesce to that request because the patient is consenting to the treatment. If that syrinx progresses so that the patient is no longer able to communicate because it causes respiratory compromise, or it extends into the brainstem and the patient is neurologically damaged, that patient, by virtue of becoming incapacitous, cannot then go to the Court of Protection and say, well, will you please look at wider issues and potentially make a declaration that this doctor was wrong in his clinical decision making and I must therefore be able to have the treatment. It's very clear in my submission, and indeed from the judgment in Aintree and James, that the Court of Protection's role or jurisdiction only arises after purely medical decision making has taken place. And it does seem that the question at the heart of this case is there truly a stage 1? Is there truly a stage of medical decision making which is entirely devoid of consideration of best interests? And when I use that term, I mean best interests in the term or in the sense that is engaged in the Court of Protection's
Section
role.
4 terms.
In Section 4 terms, exactly that.
Now, you said that's the question.
But of course,
That is, this case question has not been raised, has it, before in any case, in those terms?
in those terms, my lord, I don't believe it has. Otherwise, I
Well,
think
what's
the
prompted it?
matter would have been.
What's prompted it?
In Henke's case, that's quite right. Mr. Patel quite rightly notes that it was specifically raised in the case of AA.
And I suppose it was half raised in GUP as well.
And it, my lord, the difficulty, and I think I ought to deal with GUP now, the difficulty with that case is that, in my very respectful submission,
You said that in your skeleton.
that there has been an elision of the 3-stage process of clinical decision making there. And the court was quite rightly concerned by the treatment plan as a whole in that case. And there were elements of the treatment plan that plainly did engage the jurisdiction of the Court of Protection, and in specifically the provision of hydration. But in considering the application, the court was not addressed on a distinction between pure clinical decision making and best interest decision making. And it doesn't appear to be the case that the trust were as trenchantly as they were in AA, saying to Mr. Justice Hayden, whatever order you make, whatever declaration you make in this case, we will ignore it. Because that is the stark distinction between AA in my submission and GUP. Because in AA, the trust were, as they are in this case, saying, whatever declaration the court may make, we, and that is the clinician body, are not willing to provide that treatment. We have consulted outside our organisation and we have found no one else who is willing to provide that treatment. That was not the evidence before the court, it seems, on reading the judgment in GUP, and allowed the court, if I may say again respectfully, to elide pure medical decision making with best interest decision making.
You mentioned that there were elements of the treatment plan in GUP which were admissible to protections jurisdiction. There could be elements of a treatment plan, even on your case, of the treatment plan in this case. So, for example, if there was an argument about the palliative care to be offered, or other aspects of the, no doubt, very complicated care package to be offered to RB, that could come before the Court of Protection.
My Lord,
In
certainly.
which case the court would have the power to deal with some, but not all elements.
That's right.
And that would be those which the doctors have decided were not clinically appropriate, would be out with the court's jurisdiction, and those where the doctors had not reached such a decision would be within it.
That's right.
And at any time the doctors could hold up a red flag, could they, and say, we don't think it's clinically appropriate, so that element goes away.
My Lord, that must be right, and that could indeed happen in any case before the Court of Protection, because patients' clinical presentations will change, and it may very well be that partway through a hearing at which the court is considering, if we stay with the subject matter, dialysis, which was on offer at the outset of the proceedings, but then clinicians keeping the patient's condition under review determined that it was no longer ethical to provide it, could indeed raise the red flag partway through proceedings.
You don't tell it doesn't happen anymore. What used to happen in these cases a few years ago is that there would be an element of dialogue, cooperation, once you got into court. And the doctors were there, and the trust was there, and the judge, on high, would make a few suggestions and smile at both parties, and they would come to an element of agreement, or there'd be some modification.
My Lord, it is a matter of great regret to the official solicitor looking at the history of this case that there does appear to have been a breakdown in communication. It is, the official solicitor hasn't, in her usual role, been able to delve into, as she would if this were in proceedings and matters of best interest were being considered, the cooperation that one would expect in cases of this nature. On the basis of the information available to the official solicitor, all that we can discern is that the family were led to believe that a best interest decision was being taken, and that, it seems, having heard submissions from Mr. Patel this afternoon, might very well have been the case, but changed when the central tunnelled catheter line failed, and just as I referred to a moment ago, conditions change and therefore clinical decision making changes. That seems to have changed the complexion of this case, but on the basis of what the family have said about the way in which matters were communicated to them, it doesn't appear that communication and cooperation has been as the official solicitor would have expected it to be. But of course I can say no more than that, because we haven't been involved in the proceeding.
I've got one more question. I mustn't just run lots of time. Do you have any observations about Dr. T's involvement in this case, Ms. Watson?
My Lord, I do not. The only thing that we would say about Dr. T's involvement is that that would be something that would be explored in the event that we were in proceedings, but we are pre-proceedings and so has not been. There is nothing particularly surprising about clinicians consulting other clinicians. about how they manage patients, how they manage communication with families. But in the absence of having an opportunity to, as the official solicitor would in the normal course of events, explore the medical decision making as part of her exploration of best interests, we simply can't comment any further. It would be, to put the matter in context, usual practice, as my lord, I know you are aware, for further evidence to be requested by the official solicitor. She would want to see the medical records. She would want full statements from clinicians setting out their clinical assessment of the patient's condition and prognosis. And matters such as how has the diagnosis of PDOC or TDOC been arrived at would be fully explored if this case were in proceedings.
We've got a question to ask you and Mr. Patel in one moment, but just before we do, very conscious Mr. Quintavalli needs to have some opportunity to reply. Are there any other points that you need to bring out at this stage?
My lord, I believe that the legal structure has been covered in detail by my learned friend Mr. Patel, so there is nothing more I think I can assist with in that regard. I would ask that you consider the role of the Court of Protection as set out in Aintree and James at paragraph 18, page 774 of the bundle, when considering the limits of the court's jurisdiction.
The decision.
Paragraph 18 of the decision, 774 of the bundle. But beyond that, it may simply be of assistance to conclude with the official solicitor's position in respect of the application for interim relief.
Yes, please.
The official solicitor struggles a little with applications for interim relief in cases of this nature, because of course if the court is to make a declaration of lawfulness of treatment, even if it is limited in time, the court is being asked effectively to pronounce on the ultimate issue. And that seems, in a case such as this, to be inappropriate, but the official solicitor would certainly endorse the gentle direction given by my Lord Justice Baker on Friday to the Trust to take all steps that they consider to be clinically indicated in order to keep RB alive so that the matter can be determined. And that, I think, is as far as we can go.
Which I think leads on to the question, which is, if at the end of the day we concluded that the decision under appeal could not stand, what should happen?
In the urgent circumstances of this case, we would invite the court to take the decision again under section 50, subsection 3, and if permission to bring proceedings is granted, if it is possible, and I doubt it will be, but if it were possible for the court to make the ultimate decision, we would invite the court to do so. But in the usual course of these applications, one would expect the official solicitor to have an opportunity to act as litigation friend, and I appreciate what has been said by the family about the official solicitor's position taken as advocate, but the official solicitor would, if invited to do so, accept the court's invitation to act as litigation friend, and would then conduct her usual investigations into wider best interests, which would involve obtaining as much information as she possibly could about Mr. RB's likely wishes and feelings, and those with an interest in his welfare. So family members, we understand there are a number of family members interested in his welfare, so that the official solicitor could then take an informed view about the wider best interest question in this case.
So would you invite us to allow, if we allow the appeal to grant permission under section 50?
If
That's our view.
if that were the decision, and an opportunity, and maybe it can be done very
And
swiftly.
then would you like us to give directions, or should we ask it for?
My lord, I would invite this court to give direction so that the matter can be moved on as swiftly as possible.
Would you like to, without indicating a decision, would you be able to agree directions, do you think?
I would think so, yes. Yes. I'm optimistic, certainly, that we would be able to agree directions, my lord.
just thinking around that for one moment. On the one hand, as you recognise, this would be a matter of great urgency. On the other hand, as you say, normally the official solicitor would like to know rather more. So how would you reconcile the two objectives?
My lord, if the court were able to give an indication of its decision before providing a reasoned judgment, the official solicitor would be able to, if the decision was to retake the decision on permission and grant permission, would be able to take steps to begin her investigations and try to gather as much information as she could.
Do you
It's-
have any idea of a timescale? I mean, it's a very urgent case.
The official solicitor is well used to dealing with matters of urgency, and I would anticipate that she will do whatever she can in whatever time frame she is given. I'm seeing nodding from behind me, my lord.
It's going to have to be in front of a judge within a few days, wouldn't it?
My lord, this week certainly. Yes,
List for a hearing before the judge this week.
yes, and likely Wednesday or Thursday. But we are very much in the hands of the trust to provide an indication of Mr. RB's current condition and prognosis, which we've been led to believe was, of course, very bleak, sadly.
Normally, one would remit to the Vice President either for hearing or allocation. That sounds rather a sensitive issue at the moment. Maybe not if we're postulating, which is that the appeal is allowed. So then it would be a best interest decision.
Yes, which could, in our submission, be remitted to the Vice President.
And just before we get up, Mr. Grintavalli, Mr. Patel, anything more to say about that aspect?
My lord, no, I don't have any instructions in relation to it. But if the appeal's allowed, then the decision has to be quashed, and you can take the permission decision yourself. That's pretty much clear. But I agree, it would have to be done very, very quickly indeed, because this is a gentleman. I did include a slight update over the weekend in my skeleton argument. I don't know whether you saw that, which is that we did in fact do a blood test to ascertain the potassium levels, and we have given some treatment which we don't think is clinically indicated or appropriate, but we did it in light of Lord Justice Baker's observation on Friday, and his potassium level shows him to have a mild disease at this stage, but of course things can change very quickly.
Thank you very much. Mr. Grintavalli, I hope you can be very, very brief.
My lord, I wanted to take the court, first of all, back to the GMC guidance and treatment and careful within life for practice and decision making, tab 10, pages 333 and 334. And I just wanted to just make 2 points out of this. First of all, 14D, which is the decision-making model in patients who have capacity to decide, and my learned friend read this out, but it's very significant. If the patient, the capacitous patient, asks for treatment or care that you don't think would be clinically appropriate, so the decision that it isn't clinically available is ready to be made, you should explore the reasons for requesting it. So a decision that's made by a clinician or a trust that a treatment is not clinically appropriate is not the end of the story. This decision is then open to discussion and to re-evaluation. And that's why we say the fact that the trust has apparently said that they're refusing to provide this treatment. In fact, when we look at the evidence, there isn't any evidence popping before the court that they are refusing to provide treatment. But that shouldn't be an obstacle to the declarations being made. If we then look at the next paragraph, which is that about adults who lack capacity to decide, my learned friend didn't deal with paragraph 15, but it's a very important paragraph. It's important because if we look at 16, it says, taking account of the considerations in paragraph 15, this is the decision-making model that applies if a patient lacks capacity. And what 15 is all about is finding out the views of the patient. We're in best interest territory. The central feature of best interest territory is the views of the patient. So before you make a decision as to whether a treatment's clinically appropriate or not, you need to know what the patient thinks. And indeed, we see that over the page at 16b, where we see that the clinician uses specialist knowledge, experience, and clinical judgment together with any evidence about the patient's views to identify which options treatment is in the patient's clinical interest. So this is precisely the point we were making. In order to determine what's clinically appropriate, a best interest evaluation is part of that process. It's
In 15C, it says that if there's no advance decision and nobody has legal authority, then if you have the responsibility for the patient's treatment and care, you are responsible for deciding what would be of overall benefit to them.
Yeah.
Your best interests.
Yes. So it's this, again, there's just no carve out of clinical decisions which are exempt from court supervision. It's agreed between counsel, and I'm not going to name anyone, but I just need to say this before I make my next little submission, for obvious reasons. It is agreed between counsel that the transparency order doesn't cover the second opinion doctors. We cautiously haven't named any, and I'm not going to now, but I do need to just point out a curious aspect of the Henke judgment, and that's the very central role that Dr. T played in that. And in fact, if we look at paragraph 31 of that judgment, we see there the conclusion that...
Sorry, which tab?
Sorry, 1094, I'm looking at page tab 32. Page 1094, and we see there that this whole discussion about there being only one possible clinical treatment available seems to be very much linked to the evidence which Dr. T had given in that case, and it's I say no more than that.
So
that
which paragraph are you looking at?
Paragraph 31. But Dr. T's evidence is also mentioned in 28 and 29, and then her involvement in paragraphs 3 and 8 as well. That may explain why that case took that particular turn, and it may have something to do with the involvement.
Well, she was involved as an expert witness in that case, wasn't she?
Yes,
She
She was the treating
She's a
clinician.
treating clinician, sorry.
she seems to be advancing an argument about clinical distinction. There was talk about an assessment that the treatment is being offered to ORB is futile, in the sense, this is my note, in the sense of his overall condition, and it wouldn't be able to get him back to living the life he had before. But the whole notion of futility is one, again, which has to be assessed by reference to the patient's own view of what value they ascribe to life in a limited condition. And this is something that this is the central point in Aintree, which have to look at that very point, and why the Supreme Court said that the Court of Appeal had got it wrong, because they tried to establish an objective view of essentially of futility or value of life, and instead it was the judge who was right in placing value on how the patient would interpret or would assess the value of their life. And that, again, is something that hasn't been done in this case. There's been no attempt to assess the patient's value. I just wanted to conclude just by, I said before that there wasn't any evidence properly before the court that the trust would refuse to, obviously the fact that the trust is there is an indication that that is the case. We've been told that no doctors in the trust would be prepared to insert this line. That just seems to be an assertion. We haven't had evidence from the doctors. It is of concern because as my Lord Justice Newey pointed out, the capacitous patients the whole time have lines failing, or at least this is what I'm the thrust of the question. It can't seriously be suggested that in those cases of a capacitous patient whose line had become clotted trust would refuse to replace it. In my submission, it seems clear from the evidence that Dr. B gave that the reason they're not doing this is because of the neurological condition. And if I just wanted to refer to the witness statement of LT in paragraphs 44, 47, 49, where she talks about her conversations with Dr. D and the indications there are not that the trust is going to refuse to do things. In fact, at 47, interestingly, at a certain point, it said that they weren't proposing to put in the temporary catheter, but however, he said, this is at the end of 47, page 76 of the supplementary bundle, however, he said that the trust lawyers had instructed the doctors to place a new temporary line in his groin the following day. So it does seem as if the trust clinicians are open to being instructed by lawyers as to what their duties are in fact. And then at 49, more tellingly, this is in a section, events since 6th of February. My mother then asked Dr. B to insert a permanent line instead. Dr. B said, no, we won't have access to that equipment over the weekend and it will need to be in theatre. And as LT says, he was no longer adamantly refusing to insert the permanent line. We understood him to say simply that a line was needed urgently and the best that could be done in the weekend was a temporary one. I say this, I mean, this doesn't turn the matter either way, but we have to be very careful. The evidence before the judge was simply not that there was a categorical refusal to perform any treatment. The evidence that was properly before the court paints a very different picture. My lords, those are my submissions.
That's very helpful. Thank you very much.
I'm sorry to write, but
Sorry, Mr.
I'm not sure that's quite right in terms of the evidence before the judge, and I'll just refer you to Dr. D's statement at paragraph 15, I think it is.
End of 14.
At 14, end of 14, I beg your pardon. Where the last line of 14, it says the trust's clinical position is that no further dialysis access will be inserted and no new tunnelled line will be placed.
So paragraph 15 of
14. And that was before the judge.
My lord, I accept that, but the trust is not, it is a different entity from the individual clinicians, and that the assertions made that 30 nephrologists have refused to insert the line, we simply don't have evidence. And that's as far as I go. The trust is obviously taking its position. The fact that it's in court today bears that out, but it's not in an individual. The trust isn't speaking for, can't speak for the doctor's individual clinical decisions.
And I think we're going to have to rise in a moment to discuss things. Just before we do, where are we on transparency order? What is left to debate on that?
So as I understand it, my lord has accepted that the 2/3 second opinion doctors, legal advisors are able to be named
Under the order.
under the existing order.
Second, so-called second opinion doctors, yeah.
It's accepted that, well, as I understand, my learned friend, the trust doesn't have any objection to the trust being named. And that potentially was in breach of the order because it would identify the hospital, but there is an objection to that. But the question mark, and there isn't objection on our part on anonymity being extended for the treating clinicians in line with Abasi for a short period to enable these proceedings to come to a close and for them to make any personal application they may need to. But this isn't the case where there's been any acrimonious public outcry which has put people in fear of their person. So we'd suggest that has to be put in perspective. So Abasi doesn't say that in all cases this is standard treatment. It's where
You say for a short period, how long a period?
I would say, well, I know the reality is that the judge decided that today was adequate period. Certainly if the proceedings were to go on, we wouldn't suggest that the restrictions should remain in place more than a few days after proceedings ended.
If the appeal succeeds and the case is remitted for a substantive, and we grant permission, and the case is remitted to a judge for substantive hearing, the order should continue in whatever modified form for the time being, then the judge can decide.
Maybe that's the most sensible.
Isn't that right to do with that?
But-
We refine it for the next few days, if,
Yeah.
either way, whatever we decide.
And RB's identity remains.
Well, this is where the dispute is. The position of the family is this, that first of all, the family wishes to be identified, and they have rights in normal circumstances. Not to, people have a right not to be subjected to injunctions they don't, preventing them from being named or from telling them their stories. So they would like to be named. The question, and secondly, all these names, including RB's names, have been in the national press. And this is a very significant matter under Section 12 of the Human Rights Act, which the court has to take into account. The names are out there. They may or may, I understand the official solicitor is concerned about an article being put in the press, but it's out there now, and it's not going to be removed. It's been out in other forms and sources as well. It would be inappropriate in my submission for the clinicians haven't been named, so it would be appropriate to continue those injunctions.
So from the I'd be better to wind this up. So far as the family are concerned, there would be no objection to RB being named.
And we don't know what further evidence the court could have that would. They're saying that they've considered it carefully. It's in his. They believe he would.
You're actually asking for permission for to be allowed to name the family members and RB, are you?
Yes.
So should we just, we need to go out and talk about things. Mr. Patel, your position on that point?
On the RB point.
Yes. Well, RB and the family,
On
because
the
they go
family.
together, really.
I don't think I've got anything really to add on that. The only thing that I would say is that there has been a breach of the transparency order by way of publication since the transparency order was made. We asked, there was an article naming RB and the family after the transparency order had been made, and we asked them, that publication, to take that article down, and they haven't done so. And the only other
Which
matter,
organisation?
I think it was Christian Concern. Christian Today, I beg your pardon, Christian Today. And the only other matter is that between the application being issued, which was on the 13th, and the judge dealing with it on Monday, there were publications which named RB and the family in circumstances where it ought to have been clear from the solicitors making the application, because they're experienced in this, that that a transparency order would in due course be made. The fact that it wasn't made was the way in which the application came in late.
You accept the family's name is in the public domain?
It is as a consequence of that, yeah. So as a consequence of that happening, Mr. B's name is in the public domain as well as the family's.
Not technically in breach of transparency, but you say in circumstances where it ought to be realised there would be a transparency.
Correct.
Miss Watson, anything you?
My Lord, briefly, we simply say that simply because a transparency order had been preempted and publicity had been sought before the court receives of the matter shouldn't deprive Mr. RB of his right to confidentiality during the course of these proceedings for as long as they continue. Inevitably, if the appeal is allowed and the matter is remitted, there will be much more information about his health and condition that will be revealed in the course of those proceedings, and the official solicitor's position is that, notwithstanding that there has been publicity which the official solicitor does not consider has been appropriate, we would ask the court to continue the transparency order to protect his identity as long as the proceedings continue, and for a reasonable cooling off period thereafter. We'd suggested 28 days after the conclusion of proceedings, a rather arbitrary figure, but nonetheless we would hope would give an opportunity for matters to settle. And in respect of the family members, ordinarily the official solicitor would not take a view, but of course if family members are identified, it seems highly probable that by jigsaw identification Mr. RB will also be identified. And so it must follow that if the court considers that it is appropriate to maintain the order in respect of Mr. RB, it must therefore be appropriate to continue it in respect of family members.
Thank you very much. We'll rise from
Sorry, just one point, not related to the transparency order, but related to the question of interim relief, and it wasn't clear to me whether the court was proposing to make it. It's as expeditiously as the court may arrange further hearings, unless this interim relief is made, it's unlikely that these hearings are going to be anything but academic. This is my understanding. On the evidence that the trust presented, if dialysis wasn't given, it was likely to be a matter of days before RB would die. In fact, it's nearly been 2 weeks now, but it's unrealistic to expect that he's going to be able to survive any
I mean,
longer.
I'm certainly not a doctor. Looking at the material that Mr. Patel referred to on potassium levels and so on, and so things have got better.
What I've been told is that since the dialysis has been stopped, that RB no longer opens his eyes and he's become essentially unresponsive, as far as I understand. The fact that the potassium levels have stabilised is very positive, or that there isn't a concern about them, because this was the concern raised on Friday for not proceeding with general anaesthesia and presenting another line, because we were told that because of the risk of high potassium levels, it could be cardiac arrest. But if that isn't the case, then it would seem that that clinical concern should have subsided as well.
We'll rise from that.
All rise in favour.
We are not going to announce the decision tonight. You will be told the result of the appeal and indeed the application for permission to appeal by email early tomorrow morning, with reasons to follow. In the meantime, we will extend the transparency order in its existing form until midnight tomorrow. And at the same time that you are told the result of the applications for permission to appeal and the appeal, we will say what we consider should happen as regards the transparency order for the future. So far as interim relief is concerned, we again are not going to make any order for interim relief overnight. But when you are told tomorrow the outcome of the appeal, that will, if appropriate, also deal with the question of interim relief. But essentially the upshot is, for now, the transparency order is extended as it stands until midnight tomorrow, and you will get the result of the appeal early tomorrow morning. If I didn't say that already. But thank you all very much for your assistance.
All rise.